notwithstanding the declaration under entry 52 of list 1 falls under entry 33 of list 3.
Undoubtedly.
And the object of Parliament of the framers in putting it in entry 53 was, notwithstanding the declaration under entry 52, the states will still have power in respect of trade, commerce, production, supply and distribution.
Right. I'm not, before we come to any
entries 26 and 27, advisedly, they are not made subject to entry 52.
not made subject
to 33.
They are only subject to 33 and 24 is subject to 52, not 26 and 27. They are independent entries. So if the Parliament wants to take over anything pertaining to the trade and commerce, supply and distribution, then it has to. Now, the other correction which I may be permitted to make is,
what is your, now we've seen the entries.
No, there are two broad arguments. No? One is,
what is the theoretical structure that you have?
Now, first we say, Lord.
Anything else you want us to, let's complete the entries.
Yes, yes. Then kindly have entry 6
of
list 2. Public health and sanitation, hospitals and dispensaries. Omit the rest, not take public health into consideration. Intoxicating liquors. Now that is to say is an illustration of what follows. That intoxicating liquor, in relation to that, production, manufacture, possession, transport, purchase, sale of intoxicating liquors. The question is, what is the term intoxicating liquor stand for? The legal sense. So the question is, when the Lordships are considering this term, my request would be the Lordships will have to place the Lordships in the position of the framers and see how they saw this term at that point of time. What the law was, what was the legal history, the legal sense. It is not always that in terms of the legislative power, Lordships have relied upon the popular and the common sense point of view. Because more often than not, the entries have entirely different.
Any other entries that we have missed, or that's now the sum total?
Yes. Now, Lord, the next entry in the state list, which I would pray Lordship may have, apart from what Lordships have seen, entry 51 list sites. It says what? Duties of excise on the following goods. Manufactured or produced in the state and similar goods manufactured or produced elsewhere in India. So duties of excise on the following goods. A, alcoholic liquors for human consumption.
Is it same as intoxicating liquor?
That's the question which Lordships will have to deal with. Because why would framers use different words in two different entries? And the reason my answer is the legislative history is there. That is why.
Is there any liquor which is not intoxicating?
I don't think so. At least I have not experienced it.
The consumer, I suppose.
Just come from Holi. So
It depends on the person who drinks it. Whether it is
And how
intoxicating or
how
not.
late?
That could be strength of the effect, but effect will be there.
Consumer.
Alcoholic liquors, they all liquids containing alcohol, they are intoxicating. I can't imagine of a liquor which is not intoxicating. Be it industrial alcohol. Of course, intoxicating means alcoholic content. Industrial alcohol has higher alcoholic content, that's all. It can't be had as it is. But then, do we have whiskey as it is? Not. We have it with soda or water normally.
That
again depends. Definitely.
No, for that matter, Lord, some people do have neat liquor. But then, neat, that's what I'm trying to explain. No? The neat liquor is also more often than not mixed with ice cubes. It's not a constitutional issue. No, but it has been, Lord. Kindly have Article 47. Kindly have Article 47. It says state can prohibit consumption of alcoholic drinks. So whenever they refer to beverage form or something that can be had as it is, neat as just there, Article 47 refers to that as intoxicating drink. So a whole lot of different phrases have been used in different entries. There has to be some purpose behind it. And that is what my endeavor would be to show why. But in any case, at least one assumption I can make is, when we read entry 51 list 2, when it says alcoholic liquors for human consumption.
There is one reason possibly why they said, otherwise liquors would have been sufficient. Why do they use intoxicating liquor?
I'll ask, that is a question which legal history,
liquor, it's not the decoction. The decoction is very often referred to as a liquor, but it's not intoxicating liquor. Tea liquor,
Yeah,
absolutely. Tea liquor, coffee liquor.
Each has its own risk. The caution is made, the coffee powder is mixed chicken. Different proportion. It has been carried on from generation.
So it's liquor, but it's not the intoxicating liquor. Therefore, we have a history in our country of alcohol. It's not alcohol, but it's still referred to as liquor.
Not when we're talking of whiskey and liquor, the coffee liquor seems to be a little
UER.
UER.
Queer it's called sometimes.
Yeah, spirits. It is spirits.
My real problem in this matter is what?
The bigger problem would be what most of the lordships would do, without understanding what liquor is.
Then how you can argue with the coffee part of it?
Attorney, you have an uphill task.
No, let him have liquor, he'll conquer the hill.
The lighter side again.
So
I was appearing
Look at other way around.
Chief Justice Datu,
some of
the
us
Kerala High Court,
can do it more impartially. We know nothing about liquor.
on the more impacts on hatcheries. So then question was about 301, 304, etc. Chief Justice Datu asked me, Mr. Venkataraman, how much should you know about chickens? So I said, I don't know about the internal motion, but I know about the motions from state to state. So that was talking about coffee. There's a very important question. Liquor other than intoxication and intoxicating liquor.
That's it.
Therefore, that's the secret of INT 8. When I address your lords on that.
Attorney doesn't sound very convincing with regard to coffee.
Yes, Mr. Dev.
Now coming back to the kindly have the lordship has seen it's a taxing entry 51 list 2, and duties of excise, which means tax on production and manufacture. Now the parallel entry is there in the union list, entry 84. Lordship would have to see it before the amendment, because now 2016 GST etc. has really spoiled the shape of the entries. Pre-2016. It would be there in the footnote.
Yes, we got it in the footnote. You have to thank Mr. Shankarnarayan. No, that page 471.
Yes. Now kindly juxtapose this entry 51 with entry 84, the parallel of this entry in the union list. Because for tax purpose, it seems framers divided this entry, alcoholic liquor. So liquor was divided into two categories. Now, coming back to entry 51 again, Lord, with due respect, Lord, I'm sorry, there was something which I should have pointed out earlier. It contains three items in fact. Your Lordship would see alcoholic liquors for human consumption, that's one item. The other item is opium, Indian hemp, etc. And the third item is medicinal and toilet preparations, which are in the exclusion clause, but not including medicinal toilet preparations containing alcohol.
All these cough syrups which have alcohol will go to the center.
For tax.
For tax.
For tax. But the interesting part which I wanted to really emphasize here is, Lord, there is no regulatory entry in any of the lists, either specifying the word industrial alcohol, not for human consumption. 3.
So does it mean that industrial alcohol is not meant for human consumption?
Obviously, Lord, it can't be had because the
Nature of-
strength of the liquor is not 95%, 97%, not 90 to 95%.
Yes.
So which is dangerous for health, perhaps.
Mr. Dwivedi, you just said no regulatory entry in any list using the phrase industrial alcohol or the or I missed actually.
Or alcoholic liquor not for human consumption. I can understand, Lord, if the idea was to regulate these two, tax these two, then there should be some regulatory provision somewhere. Intoxicating liquor is one such entry, Lordship may keep it in mind. But apart from that, there is no entry to regulate industrial alcohol or alcoholic liquors not for human consumption. And more importantly, Lord, if Lordship will see medicinal and toilet preparations containing alcohol, there is no legislative entry in any of the lists. And the question, therefore, which comes to my mind, which I raised before Lordship, and I'll try to answer that. Why? Taxing entry only regulates part of it, the intoxicating liquor or alcoholic liquor. But the rest of the parts are where we don't know. We have to speculate. Synthetics puts it in entry 52 because of IDR. Now, if we put it in entry 52, then obvious thing would be that it goes to entry 24 then. Because you can't pick up from any other entry excepting 24. So far as industry is concerned, must go to entry 24. No, but which entry?
Entry 97.
No, I'll answer that. No, that's not. If entry 97 has been determined to be so huge, then what was the point in having these entries? They could have just said list 2 and 3, entry 97. But it would have included everything.
But a medicinal preparation containing alcohol, then the duty of power to levy duty of excise, where will that go according to you?
No, duty of excise is there, not entry 84.
Right.
Entry 84, list 1,
Right.
it clearly includes
Couldn't make sense.
unamended answer. It includes. So that's what I'm saying, Lord. The idea is to have these items as separate items, but
Medicinal preparations which have alcohol.
for taxation.
Act, of course, yes.
This word intoxicating liquor and the laws pertaining to alcoholic liquors.
Now we have seen the entire gamut of entries, right?
Man.
Now why don't you formulate what your points are?
Yes.
So then once we do that, we'll go to synthetics and see. It's not a very long matter.
No, it will, you will have to trace the list.
Obviously, but why don't you formulate
I
it?
would not be able to make it.
No. Obviously, we'll look at the legislative history of intoxicating liquors, but now you can just formulate what your submission is.
Yes. The first question again is, Lord, as I pointed out,
We've made a note at page 29, page
29,
30,
yes.
PDF page 30, but now why don't you formulate what your points are?
not the first question which I'm going to canvass for Lordship is that entry 8 list 2 industrial alcohol
Which confers exclusive
jurisdiction on the states to regulate industrial alcohol So the scope of entry 8
industrial alcohol is part of intoxicating liquor.
liquor, and therefore states have exclusive jurisdiction.
So your first submission is entry 8 of list 2 confers exclusive jurisdiction on states to regulate industrial alcohol because industrial alcohol is part of intoxicating liquor.
It has not been restricted by any phrases before or after,
It's a general term.
unrestricted by any other entry, unlike 24. To put it in a better formula, it's a specific entry. Industry is a general entry. This is a specific entry which at least 3 constitutional benches of lordships have held that to be. Entry. And perhaps not, it's a special entry in state list as compared to entry 24. Can include any industry. But if Lordship would see entry 8, it says production, manufacture, sale, purchase, everything is there. It includes virtually every activity relating to intoxicating. And In McDowell's case, Lordships have held this very clearly that it's a special entry as compared to industry, which is a general entry. If I may place, no? Entry 25 list 2 says gas and gas works. That's an industry. But the question which I am posing is, does it fall under word industry then? If there is a specific entry which has been carved out of the word industry, entry 24 cannot be deemed to include gas and gas works. In that sense, even. Because if industry was wide enough to include gas and gas works, then what was the point in having it there? We can't, by interpretation, make the entry redundant. Likewise, as compared to the general entry industry, entry 24.
But every other place, they say.
The power to legislate on on industrial alcohol.
Because that is to say, kindly have not the elaborateness of the illustrative part. That is to say is an illustrative word, but look at the elaborateness of the illustrative part. It says, industrial alcohol. Production, manufacture, possession, transport, purchase and sale of intoxicating liquor. What else is left then? Apart from this, I ask myself. It's a complete entry, which includes every aspect of industry, intoxicating liquor. So I have to answer that question whether intoxicating liquor is white or not.
No, the question is whether intoxicating liquor would include industrial alcohol.
Industrial alcohol.
That is the question.
That's the question. Yeah. And for that, one of the aspects which I had indicated and emphasized.
Wouldn't it postulate something which is for human consumption by its very nature?
No,
Yes.
that's one way of looking at it. As I said, this is an entry which is general and uncontrolled. Now, intoxicating can mean causing intoxication to the humans.
Yes.
It can also mean a liquor aspect that it may cause intoxication to humans when it is had as it is, as a drink, intoxicating drink. Can we have Article 47 for a moment?
But the purpose of industrial alcohol is never to intoxicate. Industrial alcohol is a completely different.
I'll answer that question. It is.
The ordinary use of the article must be seen.
Not the term industrial alcohol.
It's also evident from entry 84.
Lord, let us not confuse the two things. Lord, it may not be fit for human consumption as it is. There's not this difficulty. But to say that it is not intoxicating, that is not correct. Because it has alcohol. It has high quantity of alcohol. Therefore, it is intoxicating. Lord, we are considering the wide entry that it is and a general entry which is unrestricted. Because if it was only human consumption, then entry 51, the phraseology would have been there in entry 8. Alcoholic liquor for human consumption. That is to say, framers would not use two entirely different phrases for denoting the same thing. That's one aspect which I have. And I will show.
Because if you see entry 84 clause A as it then stood, duties of excise on tobacco and other goods manufactured or produced in India except A, alcoholic liquors for human consumption.
Quite.
There only the state can levy.
Levy duty.
Yes.
So again, the phrase is alcoholic liquor for human consumption. Now, my question to myself is that if alcoholic liquor for human consumption was a set phrase used in beverage form or which can be had by the humans, then the same phraseology should have been there in entry 8 if the idea was to indicate the same thing. And there is a reason why it is not so, because as I said, legislative
One way of looking at it is, if it is a declared industry, then obviously the state will not have any jurisdiction with regard to it. Then only the center can have the jurisdiction over that entity.
There's no difficulty. But the question which I had posed before Your Lordship was, if intoxicating liquor falls under entry 8, then it is not an industry under entry 24. And if it is not an industry under 24, then it cannot be taken over under idea. Because then the parliament would be determining the scope of the legislative entry.
We have entry 24, which says in list 2, industries subject to the provisions of entry 7 and 52 of list 1.
So therefore, classified in the state list only. One is special, the other is general. The special has been carved out. For instance, as I cited the example of gas and gas works. The Lordships would recall Calcutta gas case, no? But the Lordship specifically said it's a special entry gas and gas works.
Vedi, I've formulated your third point like this. Entry 51 and entry 54 of list 2 use the expression alcoholic liquor for human consumption. Entry 8 of list 2 you would have used the same phrase if the framers so intended. But entry 8 list 2 uses a wider phrase, namely intoxicating liquors.
Right.
If intoxicating liquor falls under entry 8 of list 2, it does not fall under entry 24 of list 2 and is therefore not subject to entry 52 of list 2.
Union cannot drag it to list 1.
That's your...
Yes.
So really speaking, I think what we now have to focus on is, what does the Constitution mean when they use the expression intoxicating liquors? And let's look at the legislative background of the use of the expression. Because, Mr. Dwivedi, then everything really either your argument of entry 8.
Yes.
Does entry 8 intoxicating liquor include as industrial alcohol?
That's right. But the alternative argument is that even if industry is the second question which I'm formulating is that even if word industry includes industrial alcohol.
Even if industry...
Word industry includes industrial alcohol.
In entry 52.
But first it has to include in entry 24.
Right. So alternatively, even if industry in entry... Alternatively,
but
even
if the industry...
Let's just hold us the thought down,
I'm sorry.
Alternatively, even if industry in entry 24 or entry 51...
52 list 1.
52 of list 1 includes...
Industrial alcohol.
Industrial alcohol.
Then whatever goes to in list 1 is the manufacture.
What?
Manufacture of industrial alcohol. And once the industrial alcohol as product of the notified industry emerges, it goes to entry 33. The product is not included in entry 24 or 52.
So what is included is industry and not the product. That's what you are saying.
Not the product. It's manufacture. It does not include trade, commerce, or production, supply, and distribution. word production has been not, I would suppose not out of caution, it has been used over, but manufacture goes to industry.
Actually, so even if we reject your point on intoxicating liquor covering industrial alcohol,
the second
the alternative, of course, but you may be right because we have not looked still at the legislative history. So we'll do it.
Lordship would look at it in the sense of a timeline, not perhaps not the alternative may appear to be the easier one to go to and decide.
Something which is pending for 14 years, there's no timeline. We have to look at both aspects. But therefore, your second limb is that even assuming it's industry within NT 24 and therefore under NT 52, rest of the product is governed by NT 33. And if it falls in NT 33, then you can levy fees.
The jurisdiction doesn't arise, Lord.
Right.
Jurisdiction of state doesn't arise. Jurisdiction is there.
Because you can levy fees then. Fees in respect of any of the entries.
If your lordships come to the conclusion about the jurisdiction part, then what can be the ambit of jurisdiction is a separate issue, which that can be adverted to, and the disputes will arise. They can keep on coming off and on and can be answered. But the issue is of state's jurisdiction, whether it is there or not, to regulate and control industrial alcohol. Now, another interesting aspect here would be, we have if I may answer here, I could overhear. It's coming there.
So these are the four submissions or the alternate submissions?
The B part of that last argument is that state will only have jurisdiction if the field is unoccupied.
Under NT 33.
And under NT 33. So the Article 254 comes in. And we have expressly stated that till date there is no legislation by the union because under the IDR Act, Section 18G is there. If I may, this would be the last limb. Section 18G of the IDR.
Section 18G, how do you formulate it? Then we look at it.
Section 18G confers an enabling power on the union to regulate the products of the notified industries. For securing equitable distribution and availability at fair price, they can regulate. And that regulation has to be through an order issued by the central government, a notified order. It's like a control order. The union has to regulate by a notified order providing for regulation.
Section 18G, we've got it on the screen here. It will be on the screen here. Yes. Section 18G is in volume 4. Page is yours, a PDF page. 577.
Now, this section 18G is traceable to entry 33 list 3. The central government, so far as it appears to it to be necessary or expedient for securing the equitable distribution and availability at fair price, or any article or class of articles relatable to any scheduled industry, may, notwithstanding anything contained in any other provision of this Act, by notified order, so may by notified order, provide for regulating the supply and distribution thereof and trade and commerce therein.
It has to be a notified order.
There has to be, because if I recall correctly, I missed it, but I'll get hold of it inside. Because Lord Chief Justice has in one of the judgment 254 has said there has to be in fact an order there. It has to be real conflict. It has to be actual conflict, not supposed conflict that in future order may be issued and then conflict may arise. So there has to be a real conflict, actual conflict before jurisdiction can be taken away. That's in the case of context of occupied field. The field is occupied only when there is an order under 18G. As my friend rightly says, not that under 254, state can still legislate and get the presidential assent should override them.
Yes.
But that's a different issue. I will not. But then that is, at least that indicates that the field has to be actually occupied.
And there is no notified order by the...
There is, at least I could not discover any notified
Right.
order. My friend has also asserted that. And in response to it, in their written submission, they don't say that there is a notified order. They say it's not required.
Right.
Samrat, if Lordship would come to my written submission. Lord, may I take Lordships to my written submission? Please. Now, there's one provision which I perhaps should have also cited. I forgot to do that one. Lordship, I have Article 47, which also has some bearing on our question. So this is a non-enforceable article. It does not impose any restriction on the legislative power, but it certainly gives an indication. The state shall regard the raising of the level of nutrition and standard of living of its people and the improvement of public health as among its primary duties. And in particular, the state shall endeavor to bring about prohibition of consumption except for medicinal purpose of intoxicating drinks. So where they wanted to restrict to beverage form, which is had as it is, they use the term intoxicating drinks.
The question whether he had
Consumption. This shows in the beverage form it is there as intoxicating drink in the Constitution. The framers recognized it as such. But then equate it with intoxicating liquor, again becomes a little difficult. I'm not...
Now that you've formulated, now let's go to the legislative history and then the few cases you want to cite.
Right.
I think by lunch we should be done with your submission. I think we'll give you still about 1 hour and 7 minutes.
I don't think not. It has taken nearly an hour and a half to elaborate on the entries.
But we've now got the gist of the point. Now we just go rapid fire with your with supporting your submissions.
Lord, I would only request is not. It's an important issue. Not then where rapid fire may lead to leaving out something which is important. And that is what happened. The rapid fire happened in synthetics too. As a consequence of which lots of things didn't come there.
Mr. Dwedi, the Chief Justice has to always say that, not because it's going to be enforced, but because the clock on the other side constantly stares at that other place.
At the very initial stage, I had said, Lord, if Lordship are going to determine the scope of the argument in terms of timeline, Lord, then perhaps I'll have lots of difficulty.
Lines now because there's so much of work and
not for such an issue which is there not rankling since 1951. This is an issue decided for the first time in 51, and since then it continued for 38.
The reason for the reference and everything is not because it was so complex or something, but because perceptions change. Our perception of what India is today is very different from the perception which judges had in 1950 or 1960. There's a new dimension to states' rights as federalism has progressed. Yes. There are a lot of reasons why we continually relook at our judgment.
There are two answers to it. There are two answers.
Go to your written submissions now directly.
Yes, but before that, there are two answers to it. But federalism concept is to my aid. The other thing is, the evolution takes place, new things are discovered, new things happen. But then what Lordships have said, that the legislative entries must be interpreted in an expansive manner to include the new things and new situations. But that doesn't mean that the old gets lost. The old will be there. Plus, additionally, this will come.
Submissions.
Yes.
And see how you are first and foremost saying that entry 8 covers intoxicating liquor. That's the first major submission which you have. And the second is in the alternative.
Now kindly come to my written submissions, page 2 and volume 1A. Page 2. Page 2. At the bottom, Lordship would notice there is a word intoxicating liquor under entry 8 list 2. Have Lordship got? It is important to note that the word industrial alcohol, IA for short, is nowhere used in any of the lists. Entry 8 list 2 only uses the phrase intoxicating liquor, which has a rich and deep history, and the legislative practice accompanying it. It is therefore relevant to notice the history behind this phrase. It has been repeatedly held that the legislative entries are fields of legislation, and therefore, Lordship, this principle is well known, but the first principle is well known, so I need not take time. Then the second aspect is also well known. Then the third aspect, the important part in this is that there is a necessity, starts with the context. Contextual interpretation out of necessity starts with historical perspective, particularly the legislative practice. That is what we broadly call legal sense. Now, there is one decision which I really wanted to place before your Lordships, if Lordship would permit. 1959, 1 SCR 379. And the relevant pages are
1959,
59, volume 1 SCR 379, page 390 to 391, then 397 to 413. This decision is not 51, 1 SCR is in volume 5B, page 481. 481. PDF page 486, Andrew.
volume 5D.
5. Now, the reason why I want to cite this judgment is this is the 5B. Calendar card.
On what proposition do you cite it?
Yes. In this case, the real dispute was with regard to tax on sale of goods. So the question arose, what is the meaning of the term sale of goods as understood by the framers or the lawmakers? This was the case under 1935 Act. Therefore, the entry was the same. They said, what is
So what
the
is
meaning
it called?
Their Lordships debated the question whether we should adopt the popular sense or the common sense point of view with respect to legislative entry, or we should adopt a sense which is in conformity with the legislative practice, which they call the legal sense. And eventually, after considering everything and lots of judgments, both US Supreme Court in British matters, Privy Council and all, they came to the conclusion that the real meaning can be derived after looking into the legal history. That is the legal sense, not the popular sense. That's not always correct.
From legal history, yes.
Well,
How this had been used even before the adoption of that entry in
because what they said,
the
Lordship,
Government of India.
quite right. And what the Lordship said, that the Lordships would have to sit in the position of the framers
Fair enough.
and see what the law was. In what sense?
Really, I don't think we need to labor that point, really.
No.
Let's go.
This is what, but I wanted to rely on this.
Absolutely.
Therefore.
Perfect.
And 51, therefore, Supreme Court SCR, the one above Balsara. This is 1951 SCR 682.
Yes.
This is Balsara versus State of Bombay. Or State of Bombay versus Balsara.
Where do we find it in the volumes? Volume 5B?
Volume 5. 5B.
5B, right?
5 only. Only 5.
5.
Volume 5, page 1718.
And what does it say? I mean, you can just formulate it for us.
In Balsara, not the question, of course, the case was with regard to potable liquor,
Yes.
but they considered the history of the term intoxicating liquor.
I think Balsara we maybe have to look at.
Yes. They considered the entire history of intoxicating liquor from the British position to Government of India, because Government of India is an act of British
Let's go to
Parliament.
Balsara.
Yes.
I think Balsara we may see, you know.
Regarding potable liquor.
Yeah.
And then they said intoxicating liquor would include all kinds of liquors, including industrial alcohol. No, there is a difficulty. Not, I have it in SCR form. Your Lordships have it perhaps in AIR form.
Everybody should cite SCR because we have a DG SCR in place now.
Right. So I have it in SCR form. Not your Lordships have. Yeah, I have it.
And with petrol certificates.
Then that is just opposite.
It is 1951.
82.
SCR. 1951 SCR, page 682.
You can load it for us on the DG SCR, you can load it on the screen.
Yes.
So that's the official report.
He has given SCC on that.
You've given SCC on that.
And this further went to the extent of saying even medicinal preparations containing alcohol would come under intoxicating liquor.
Which are the relevant paragraphs?
Yes. But actually, I am from SCR blood. I can give you Lordships relevant pages. I can't give the relevant.
Alright, you just load it for us on our screen so that we can both follow both the. Wo kar lo, DG SCR kar lo.
Also, we don't have volume.
It has come.
DG SCR. ESCR दे दिया आपने.
The neutral citation. See this behind.
Want us to go to?
Yes, but kindly notice the question here which arose, no? Page 685 and 686. Question is with regard to, obviously, as I said, was against the direction of the Prohibition Commissioner of Bombay, prohibiting.
So where do you want us to go to now?
Can you have the next page, 686? The second paragraph. The act in question was passed by the legislature of the province of Bombay. This was an act under Government of India Act, not 1949 Act, therefore Government of India Act, and the entry was entry 31, which is in the same terms, not as entry 8. It's intoxicating.
page do you want us now? Let's go where they discuss liquor and, intoxicating
That's
liquor.
page 703.
Page 703 page out. That's how it happens to you.
The High Court has held that the word liquor starts like that. Achha.
That's 39 in our.
High Court. Before that, Lordship may have a look at the entry. Entry 31 is at page 690. Page 690. It says entry 31 list 2. Intoxicating liquors and narcotic drugs, that is to say production, manufacture, possession, transport, purchase, sale of intoxicating liquors, opium and so on. We're not concerned with opium and all, but intoxicating liquors was the word they used. Coming to page 703. And this law was claimed to have been made under entry 31, list 2 of the Government of India Act 1935.
Slightly above this is a definition of liquor.
Oxford English Dictionary.
Earlier, just slightly earlier. Liquor includes spirit of wine, etc. Just above this paragraph, starting from High Court has held.
The High Court has held, yes. The High Court has held that the word, may I?
Paragraph 39 in this. It defines the.
May I place it one? But in the Bombay Act, perhaps there was the definition of the word liquor,
That's it.
which included spirits of wine, methylated spirit, and all liquids consisting of alcohol. Then the answer is given by the High Court, which is page 703. The High Court has held that the word liquor ordinarily means a strong drink as opposed to soft drink, but it must in any event be a beverage which is ordinarily drunk. Proceeding upon this view, the High Court has held that although the legislature may, while legislating under entry 31, prevent the consumption of non-intoxicating beverages and also prevent the use as drinks of alcoholic liquids, which are not normally consumed as drinks, it cannot prevent the legislature the legitimate use of alcoholic preparations, which are not beverages, nor the use of medicinal preparations containing alcohol. This view of the High Court was very strongly supported on the one hand and equally strongly challenged on the other before us, and I therefore proceed to deal with it. Now then the Lordships go to the dictionary meaning. In the Oxford English Dictionary, edited by James Murray, several meanings are given to the word liquor, of which the following may be known. Quoted. Liquor, a liquid matter in a liquid state, in wider sense, a fluid. A liquid or a prepared solution used as a wash or bath and in many processes in the industrial arts. Liquid for drinking, beverage drink, now almost exclusively a drink produced by fermentation or distillation, malt, liquor, liquor brewed from malt, ale, beer, porter, etc. The water in which meat has been boiled, both sauce, the fat in which bacon, fish or the like has been fried, the liquid produced by infusion. Lordship may admit the rest, and come to the next page. Thus, according to the dictionary, the word liquor may have a general meaning in the sense of a liquid, or it may have a special meaning, which is the third meaning assigned to it in the extract quoted above. Vis-a-vis a drink or beverage produced by fermentation or distillation. The latter is undoubtedly the popular and the most widely accepted meaning of and the basic idea of beverage seems rather prominently to run through the main provisions of the various acts of this country, as well as America and England's relating to intoxicating liquor, to which our attention was drawn. But at the same time, on the reference to these very acts, it is difficult to hold that they deal exclusively with beverages and are not applicable to certain articles which are, strictly speaking, not beverages. A few instances will make the point clear. In the National Prohibition Act 1919 of America, the word liquor and intoxicating liquor are used as having the same meaning, and the definition states that these words shall be construed to include alcohol, brandy, whiskey, rum, gin, beer, ale, water, wine, and in addition thereto, any spirituous, vinous, malt, or fermented liquor, liquid, and compounds, whether medicated, proprietary, patented, or not, and by whatever name called, containing 1/2 of 1% of more or more of alcohol by volume, which are fit for use as beverage purpose. Having defined liquor and intoxicating liquor rather widely, the Woolstead Act accepted denatured alcohol, medicinal preparations, toilet and antiseptic preparations, flavoring extracts and syrups, vinegar and preserved sweet cider, which suggests that they were included in the definition. In some of these items, we have the qualifying words unfit for use for beverage purposes. But the heading of the Section 4 of Woolstead Act, under which these exceptions are enumerated, the exempted liquors.
Mr. Dwivedi, if you go to para 40, we are in para 44, which says coming now to the various definitions. Middle of that para.
Yes.
If you go to the middle of that para, even if we exclude the American and English acts from our consideration,
Right.
we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor.
May I place it, Lordship?
Yes, you can just read from there, even if we...
Lordship was reading. In the Bengal Excise Act, now the first...
the para is coming now to the various definitions.
All right. Coming now to the...
Middle of that para.
No, I have it.
Even if we...
Coming now to the definition.
No, just skip that. Even if we exclude the American and English acts. That's the ratio.
But can you have it from before? Because it refers to the local acts.
Just the formulation is even if we exclude the American. That's what we are relying on.
No, they were relying upon Indian acts too earlier.
That's not necessary now. Just go to even if we. Even if we exclude the American and English acts from our consideration, we find that all the provincial acts of this country have consistently included liquids containing alcohol in the definition of liquor and intoxicating liquor. The framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in the various excise acts of this country. And accordingly, I consider the appropriate conclusion to be that the word liquor covers not only those alcoholic liquids which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. It may be that the latter meaning is not the meaning which is attributed to the word liquor in common parlance, especially when that word is prefixed by the qualifying word intoxicating. But in my opinion, having regard to the numerous statutory definitions of the word, such a meaning could not have been intended to be excluded from the scope of the term intoxicating liquor used in entry 31 of list 2.
Man. And this is entry 31 is entry 8
is entry
of the Constitution. Now, Lord, to kind of corroborate this reasoning, if Lordship would come to my written submissions, Lord, I have extracted all the definitions of liquor in the local acts. And these are all of I think 1950.
Anything more in this judgment that you want to? This is the point you want to?
No, that's the point, Chairman.
All right, then we'll close this judgment now. What is the next point?
No, kindly come to the Lord, page 8 of my written submissions.
All right, we'll go to
where I have extracted the definitions of liquor, intoxicating liquor, alcoholic liquor, and so forth. But a lot flows from that. Page 8 of my written submissions. Page 8. Page 8.
Yes.
So these are the backdrops on the basis of which entry 31 of Government of India Act was enacted, and that was borrowed by the Constitution. Page 8 note, first is Bombay Abkari Act 1878. Liquor includes spirits of wine, methylated spirit, which is not potable, it's poisonous. Spirits is defined later on, but I'll show that. Means any liquor containing alcohol and obtained by distillation, whether it is denatured or not. That's the important part. So they were quite conscious of the fact that there is something like denatured spirit, which is not potable. And then section 315, which may have little below that, excisable article, uses the phrase, because excisable article means and includes any liquor or intoxicating drink, as hereinbefore defined. Then note Madras Abkari Act, again note, spirit means any liquor containing alcohol and obtained by distillation, whether it is denatured or not. Then, can you turn over to the next page, 39, definition of word liquor. Liquor includes spirits of wine, methylated spirits, wine, toddy, beer, and all liquids consisting of or containing alcohol. Then excisable article. Any alcoholic liquor for human consumption. Now, the distinction is made here from liquor and alcoholic liquor for human consumption for tax purpose. Then this is followed in the next act also, the Bengal Act. Any liquor for human consumption, excisable article, any liquor for human consumption, it follows the same pattern. Not? And then not, it defines in section 2, intoxicant, means any liquor. Lordship may leave the rest. No? Kindly see section 2:14, liquor. Means liquid consisting of or containing alcohol and includes spirits of wine, spirits, wine, toddy, pachwai, not to remember the rest. Section 219, spirit. Means any liquor containing alcohol obtained by distillation, whether it is denatured or not. Then the Bihar Act follows the same pattern. These are around the same vintage. Excisable article, any alcoholic liquor for human consumption. Section 214 defines liquor, includes all liquids consisting or containing alcohol. And then spirit means any liquor containing alcohol obtained by distillation, whether it is denatured or not. Then comes not the MP Excise Act, which is same vintage. The same pattern, Lordship would notice. Alcoholic liquor for human consumption, so far as the excise duty is concerned. Liquor, defined not widely, includes all spirits, all liquids consisting or containing alcohol. And the spirit is defined as widely, including denatured spirit also. So spirit is part of liquor, and the denatured spirit is also part of liquor. Likewise, when you come to Punjab Act, 14, which applied to Delhi, Haryana, Himachal Pradesh, and all these. Here there is an interesting thing which comes in now. Section 214, liquor means intoxicating liquor and includes all liquids consisting of or containing alcohol. Not to omit the rest, not spirit means any liquor containing alcohol obtained by distillation, whether denatured or not. So in other words, even denatured spirit was part of intoxicating liquor. Intoxicating liquor means intoxicating liquor, both are equated. Then Lord, the same pattern is followed in the Chhattisgarh Act of 1950. For tax purpose, alcoholic liquor for human consumption is used. Section 213 defines liquor. Liquor means intoxicating liquor and includes spirits of wine, spirit, all liquids consisting or containing alcohol. Then spirit is defined to include even denatured spirit. Again, Lord, UP Excise Act of the same vintage follows the same pattern, exactly the same pattern.
Your contention is that all liquid containing alcohol
Was part of intoxicating liquor.
is part of intoxicating liquor.
And not only that, Lord, with due respect, Lord, Lordship has seen that page 7 of my written submissions. PDF page 8. There is something more to be said. And I'm only basing this on the fact not that we have followed the Government of India Act 1935, which is an act of British Parliament. So therefore, the pattern and thinking would be the same as it was there. And if in 31 that was the concept, then that has to be the same in the Constitution because framers adopted the same. Now the legislative practice, may I place it? The legislative, page 7, parent submissions. The legislative practice leads us to British position and therefore to laws prevailing therein. License Consolidation Act of 1910, Section 110, Spirits Act 1910, Section 3, 4, 5, and 6. Now the License Consolidation Act not uses the term spirit as well as intoxicating liquor for licensing. Then these excise acts have come.
So the liquor will include all liquid containing alcohol. No doubt about it. Because when the legislature or the Constitution uses the expression liquor, it means all liquid containing alcohol. But when the word liquor is qualified by the word intoxicating, does that make any difference to that?
Exactly. No, this is what I
Would intoxicating liquor also mean all liquor containing alcohol, which would include all liquids containing denatured spirit also? That's your contention.
That's because not every liquid containing alcohol is included as intoxicating liquor. Intoxicating liquor means liquor. Liquor means intoxicating liquor. That is evident from the pattern of these acts.
Liquor by itself would mean any liquid containing alcohol.
That's true.
All right. That from what? Sorry? Any intoxicating.
But how?
Usually, not what perhaps is pointed out is that perhaps there can be a drug in a liquid form, which may be intoxicating. So therefore, it can be a liquid containing intoxicant. So word intoxicant was wider.
Intoxicating does not mean that it has to be capable of human consumption.
It indicates the potentiality of the item, that there is alcohol in it, and therefore it is intoxicating. It can mean both, something had as it is, as well as a beverage, or as well as liquid containing alcohol, because that is intoxicating. Now, for instance, take the instance of the country liquor. A country liquor is extremely common all around in most of the states, and is the highest revenue churner in the states, perhaps. Now, what is country liquor? If I may place before your lordships that chart we had prepared to explain to your lordships the term intoxicating liquor. बता दीजिए. A rectified spirit. Actually, the base is the rectified spirit. He's in the most convenient form. We have tried to explain the process that will help in understanding of the commodity with which we are dealing.
Mr. Dwivedi, can we you are showing us the definitions of the Excise Act, various states. So, as the Chief Justice said, all liquid containing alcohol will come within that state. Now, whether it brings joy to the human, it must bring joy to the revenue. Is that what you are trying to say?
Quite right. It does bring quite a joy to the revenue, because most of the states which tried to apply prohibition failed and had to reverse their policies. So it is really joyous for the state to have. And liquor is really flogged as the most revenue-generating device. There's no doubt about it in our country, and therefore every state wants to control it. But the important part is not see. The chart which we have indicated, the process of manufacturing spirit. It is a heavy, dark colored, viscous liquid, molasses, because that's the basic raw material, molasses. It is the heavy, dark colored, viscous liquid produced in the final stage of manufacturing of sugar, and it is the byproduct in the sugar industry and raw material for the manufacturing of alcohol. Now, how does it happen? Fermentation. Firstly, the viscous liquid obtained from the sugar industry is mixed with water and yeast. It is also added to convert the fermentable sugars present in the molasses into alcohol. By the process of fermentation, a saccharine solution is obtained, which is also known as fermented wash. In the fermented wash obtained during this process, only 10 to 11% alcohol is generated in the total volume. Fermented wash is conveyed from the wash backs to the stills columns in closed pipes. In the process of separating ethyl alcohol from the fermented wash, and in this process, various components of the mixture are separated by virtue of their difference in boiling points. During the process of distillation, impurities like acetaldehyde, fused oil, impure spirits, which are not fit for human consumption, are removed. The product comes to be rectified spirit having strength of 91% to 95% after the process of distillation. Now, this is not ethyl spirit or the rectified spirit as we call it. Redistillation. In order to further remove the impurities, redistillation is done. After redistillation, the product comes to be extra neutral alcohol having strength of 95 to 97% volume by volume, meaning thereby out of 100 liters of ENA, 95% to 97 is alcohol. This distilled liquor can be aged or unaged to produce potable alcohol. For aged distilled liquor, maturation is required. For unaged distilled liquor, no maturation is required. Vodka, gin, country liquor are examples where maturation is not required. This fact clearly shows that the liquor before maturation is also fit for human consumption. Now, the two columns note the maturation. For maturing of IMFL, Indian made foreign liquor, maturation is only to improve the quality of alcohol, and in this process, ENA is stored in the wooden vats for the period of 1 year or 2 years or 5 years, 10 years, 12 years and 18 years, in which chemical changes occur during storage. As the spirit in the container moves back and forth through the wood, the ingredients, including flavoring compounds, are extracted from the wood and carried back into the container's contents on its own. Now, their column is not, Lordship, you see the rectified spirit which I was talking about. After distillation or redistillation, the extra neutral alcohol becomes fit for human consumption. One is required to add only demineralized water into ENA, having strength of 95 to 97% volume by volume in India. Country liquor is manufactured simply by adding demineralized water essence plus caramel into the ENA to bring its strength to 25%. So you dilute it because it can't be had as it is. It will really burn your intestines. To bring its strength to 25% volume by volume for plain country spirit and to 36% for manufacturing of spice country spirit. For preparation of it, this is important note. Since ENA is fit for human consumption, it is also used for the purposes of preparation of medicines. Lord, nowadays, Lord, what is interesting is to see, Lord, there are liquors of all kinds which are potable, like for instance, whiskeys and vodkas and all. They go up to 72%, 57, 60%, 72%. Recently, I discovered a potable liquor consisting of 92%. So, Lord, as the Lordship said, Lord, as the time passes, new things come in, new concepts emerge. People keep on experimenting. They want the strongest drink possible. Therefore, they get it. The second aspect of it is important. If you also could turn to the page 7 of my written submission. Blood, because there are blended whiskies, there are single malts. Addition of demineralized water, reduction of spirit, dilution. Addition of demineralized water in the alcohol is done to bring the higher strength to lower strength. In the case of Indian-made foreign liquor, by adding demineralized water, strength of 90% V by V to 97 V by V is brought down to 42%. And the desired strength as per the norms. Then it is bottled. Not, I need not go into that. Well, the basic idea is to, I'm sorry. So far as page 7. But before that, the term portability, which is now being used with regard to entry 8. Portability is a not relative concept. Portability can mean not something had as it is, like intoxicating drink. We have a peg of whiskey or a vodka or something like that. That's intoxicating drink and portable. That's one aspect of portability. The other aspect of portability is that you add something to it and you diffuse it and then make it drinkable. How much you want to reduce and diffuse the strength of the liquor that is as per your choice.
But it is something which is fit for human consumption. Portable liquor.
Portable liquor can mean both. This is what I've seen. That it is fit for consumption as it is. Or maybe after putting in something into it and then making it consumable. That is by
as opposed to industrial alcohol. We have
industrial alcohol can be used for industrial purpose also, like producing chemicals.
Industrial alcohol is not portable.
As it is not. But then rectified spirit of not 95% or 94%, by just adding water, you are reducing the strength of the rectified spirit and having it. Unless, of course, it is denatured. Denatured means then you are adding an item into it which perhaps makes it nauseous and, of course, poisonous.
Really, the word intoxicating does not really mean that it has to be fit for human consumption.
As
it's a liquid, it's an alcohol in which, it's a liquid in which alcohol is being added.
Yeah. Liquid containing alcohol.
You're relying on the legislative history, which was referred to in Balsara's case 1. And second, that the Constitution, when it wanted to use related to alcohol fit for human consumption, it did so in entry 84 of list 1 and entry 51 of list 2. Entry 8 is designedly only intoxicating liquors, and therefore intoxicating cannot be conflated with fit for human consumption, according to you.
And I may be repeating myself, but after all, lordships have always held in so many decisions that why use two different phrases for denoting the same thing? Once different phrases are used, then obvious intention is that it denotes something different. And so widely different. Now, the other thing which I wanted to emphasize on is, please notice this. Government of India Act comes in 1935, and for the first time it uses the word intoxicating liquor, entry 31. It has entry 40, which again is parallel to entry 51 list 2.
This is okay, no? So the Government of India Act of 1935.
For the first time in India, used the phrase, not in the constitutional statute, the word intoxicating liquor comes in entry 31. And it's in the same form as entry 8. In fact, the framers have borrowed it from there. And at the same time, they use the same phraseology as in entry 51 list 2. Alcoholic liquor for human consumption in entry 40, which is excise duty. Same as 51 list 2.
Can you say that again?
In entry 40, the same phraseology as in entry 51 list 2, alcoholic liquor for human consumption has been used. When I had placed the local acts as forming the backdrop, surely not the makers of the Government of India Act were aware of those local acts. Their own Liquor Licensing Act, which used the term intoxicating liquor. Their Spirit Act of 1870, which used both denatured as well as And it was used for licensing in the Intoxicating Liquor Act of 1910. I have indicated that in page 7, no? This aspect, page 7 to 8. But an interesting factor which I wanted to bring to your Lordship's notice in this regard is this. When Government of India Act Entry 31 uses the same phraseology as the local acts, intoxicating liquor, then obviously it had in mind that intoxicating liquor which was defined in most of the local acts. That has been borrowed in the government, in the Constitution of India. Obviously, it follows the same thing. Now, in entry 8, the word intoxicating liquor is there. They have followed that. In entry 51 or entry 40 list 2 of the Government of India Act and entry 51 list 2 of the Constitution, they have followed the same pattern as in
entry 84 list 1
and entry 4. But first, it is entry 51 list 2 in the state list. And then the excluded part goes to entry 54 list 1.
No, entry 84 list 1 as
I'm sorry, entry 84.
But then you see entry 8 list 2 is not a taxing entry. But entry 51 list 2 is a taxing entry.
Quite right. So we are not in the issue is not tax here. Issue is regulatory power, licensing power.
The two are different.
So what I am saying is, again, Lord, it corroborates my viewpoint that taxing entry cannot be used to curtail the...
That we are entitled to levy a tax.
No, I'm not.
Not say that I'm entitled to regulate under entry 88, under entry 8, and as incidental to the regulation, I can impose a fee under entry 66 of list.
Under entry 66. I'm not even for a moment claiming that we have a power to impose tax on denatured spirit or perhaps industrial alcohol. No. We don't have. Entry 84 is clear.
Yes.
And there is no taxing entry other than entry 51 list 2 in the state list. So we can't. But it hardly matters. It doesn't make much of a difference because liquor is nothing but a good. Denatured spirit would be a good. It can be taxed as sales tax. Likewise, it is a good. It can be taxed under entry 52. That is entry tax earlier. So it's not that we can't tax denatured spirit or something. It can be taxed in other forms. That is sales tax, entry tax, and other local taxes. That can be done. But of course, state by itself cannot tax it as a excise duty. That power is not available. To say there is no power to tax industrial alcohol is not correct, with due respect. It is correct to say that we do not have the power to impose excise duty on industrial alcohol. That is correct. In fact, after synthetics clearly held in paragraph 86, that the state will not have power to impose sales or purchase tax. Once IDR is there. That had to be clarified by synthetics third case.
Yes.
It doesn't deal with sale and purchase tax, therefore it couldn't be held to be law on that, laying down law on that. So, interesting part what I'm saying is, if the Government of India Act, when it followed excisable article by specifying the alcoholic liquor for human consumption and incorporated that in entry 40, and it continued to follow intoxicating liquor and put it in entry 31, then obviously they were seeing the difference. And therefore, for separate things, they were incorporating it in a separate phraseology. We can't mix up entry 51 list 2 and say it kind of restricts entry 8. Because that's a taxing entry, this is a regulatory entry, and both lordships have held in so many cases separate. So taxing entry cannot color the regulatory entry. Just as regulatory entry cannot lead to enforcement of and imposing of tax. So it would be quite unimaginable to think that the Government of India, framers of Government of India Act and the Constitution partly followed the local laws and they did not follow the local laws in other respect. No, that doesn't make sense.
Sure.
In this
And can
Yes.
complete their submissions.
But there is also a word called alcoholic liquor in entry 51 list to lordships have seen. Now, alcoholic liquor obviously is very wide, therefore they divided by saying for consumption. And if we read the definitions in the local acts, it contains all liquids consisting of alcohol, which would be alcoholic liquor. So therefore, intoxicating liquor means intoxicating liquor and contains all liquids consisting of alcohol, obviously means alcoholic liquor.
Now, for instance, entry 54 after the 101st Amendment says taxes on alcoholic liquor for human consumption.
Yes.
That's right.
So state doesn't have the power to tax industrial alcohol. That is, it can only impose tax in respect of alcoholic liquor for human consumption. But that does not, as I said, mean that state cannot impose any tax on industrial alcohol. It can sales tax. It can the entry tax. I mean, after all, industrial alcohol is nothing but goods. The entry tax, it says goods brought in for sale and consumption, for use. So it's not correct to say that the entire field of taxation goes.
Let's look at the submission so that we then conclude that part.
Page 7, I was placing. And I would pray kindly permit me to place the entire page, and this one page only. The legislative practice leads us to British position, therefore to laws prevailing therein. License consolidation.
Which
PDF.
page number?
The written submission that I was placing, page 7.
6 large 2 lines.
Page number 6-7, what also in
6 large 2 lines. Registered.
The legislative practice.
I'm sorry, there seems to be some confusion.
You got it. You got your PDF page 7 bottom.
The legislative practice leads us to British position and therefore to laws prevailing therein. License Consolidation Act 1910, as I already told your lordships, it includes the word intoxicating liquor. B. Spirits Act 1980, which includes the denatured spirit. Spirit Act defines spirit very widely to cover both potable and non-potable liquor. Section 3 to 5, 116. It deals with manufacture, distillation, retailing, etc. of spirits, while Licensing Act of 1910 deals with licensing or distribution. Word intoxicating liquor is defined there to include spirit of all kinds, including fermented and distilled. British position is clear that intoxicating liquor includes all kinds of spirits. The later 1910 Act used this term compendiously to include all spirits, all kinds of spirits, while spirit under 1880 Act included liquor of all kinds. Thus, in England, both the terms were understood and used interchangeably. That's what the Lordship would notice Balsara says. It notices these two acts. Then the Government of India Act 1915, section 45, 79 to 81. The devolution rules made under section 45A and section 129 of Government of India Act 1915 distinguished the functions and jurisdictions of local governments and that of the Governor General or the Indian legislature. The subjects have been classified as central or provincial subjects. Part 2 of the Schedule 1 of the rules mentions item 16 as excise and alcoholic liquor. It is around this time and thereabout various state enactments were framed pertaining to the alcoholic liquors. What is important to notice is not right from the earliest position, the local laws, the Government of India Act, and so on and so forth, Lord, the state had the complete control and jurisdiction of intoxicating liquor. Earlier, under the Government of India Act 1915, even the excise duty in respect of entire intoxicating liquor was with the state, which was separated for the first time in Government of India Act 1935, where industrial alcohol was put in the ken of union and potable alcohol in the ken of the state. That was the position. And it was in the light of this position leaving the extracts of local laws. Let's kindly come to para 12, page 12.
Page?
Page 12.
Page 12 of the not written submissions. Volume 1. Volume 1. In all the state laws, word liquor and spirit are defined as including all liquids containing alcohol. In some acts, word intoxicant is used to define liquor as comprising all liquids containing alcohol. Additionally, in some local acts, liquor means intoxicating liquor and includes all liquids containing alcohol. It is also noticeable that all the local acts were alive and aware of industrial alcohol and denatured spirit being integral part of spirit or liquor. Reading all the above definitions, it becomes apparent that excise, liquor, and spirits have always been part of state jurisdictions, including industrial alcohol. Center did not have any jurisdiction in this regard. The legislatures were always aware of the industrial use of the alcohol, and the local legislatures were dealing with it. Liquor and spirit traditionally included all liquids consisting alcohol, and industrial alcohol is a liquid containing alcohol. There cannot be any alcohol or liquor which does not cause intoxication. Lord Justice. Therefore, any liquid containing alcohol would be capable of causing intoxication. It was in this sense word intoxicating liquor were defined. Intoxicating liquor only follows the past legislative history for convenience as part of the settled vocabulary position, which it had come to denote. Then, Lordship, I omit this note. Then on page 14, Lord, I just rush through it. No? Page 14, the latter half, Lord, the importance of legislative practice and past history can never be minimized. This constitutes an important aspect of context as indicated above. For determining the scope of legislative power field, one has to have regard to what legislative practice it ordinarily embraces. And these are the four questions, four cases. And then kindly add this case note, 1959, 1 SCR 379, which I had referred to.
Yes.
Canon Dunkerley's case, which says that it is preferable to have legal sense rather than.
Therefore, there would be a dichotomy, if your submission is correct, namely that the regulatory power over industrial alcohol would vest with the states. But insofar as the taxing power is concerned,
that goes to
the taxing power over industrial alcohol goes to the center.
But again, Lord, if I may remind Lordship, the difference is when we talk of taxing power, excise duty is not the only tax. It's a tax on manufacture only. But then rest of the tax state can impose, like sales tax, entry tax, and other local taxes.
Yes.
Right. So these are the cases where I had not. But then the important aspect here again is not, let us fall back on the question state, the union claims or the synthetic sales entry 52 is the source of power to regulate industrial alcohol, exclusive power. then as I pointed out, then that source leads us to entry 24. Now, if industry word includes industrial alcohol and intoxicating liquor means something else, it doesn't make, with due respect, not taking the past into consideration, it doesn't make sense. If the power had to be given to the state, originally, if the power had to vest in the state under entry 24, then I possibly can't imagine why the framers would have not put it in not entry 8 rather than entry 24, which is a general vague entry to be searched and traced by a lordships, not through legal arguments and dictionaries and things like that. I mean, framers had not enumerated the lists in a very carefully planned and perhaps elaborate manner. Why would they commit this kind of a confusion? So therefore to trace to trace industrial alcohol to entry 52 would be absolutely illogical. That apart, Lordship, again, I'll come to what fell from Justice Chandrachud. Why not entry 97? Entry 97 is a residuary entry which is supposed to be used in exceptional.
There's no other state list entry of.
So the first thing we have to see is whether there is a state entry or any entry in the concurrent
list or a concurrent list entry.
So if in list 2 and 3 there is any entry which can logically trace this within itself, then entry 97 cannot be used. But then there's another difficulty, Lordship will notice. If the union traces it to entry 52, then obviously for that reason also entry 97 cannot be used. Because then it falls in entry 24. And intoxicating liquor and industrial alcohol would be in entry 24 basically, and it can be drawn over to entry 52. So this again reduces our difficulty for placing it in entry 97. It can't go to entry 97 because it has been traced to 52. And 52 means 24, which means state list.
Entry 24 is subject to list entry 52 of list 1.
But
suppose it is declared industry under entry 52 list 1.
Right.
It can be any industry which is declared by the parliament.
No, that's the difficulty. It can only be that industry which is in entry 24. So entry 24 cannot include an industry, for instance, entry 25. That is also an industry. And I'll cite 2-3 cases on that. That will clarify it. The first decision which comes to mind is Calcutta Gas, 1962.
What is the meaning to be given to entry 52 list 1?
Yes.
That cannot be curtailed on the principle of what is called parliamentary supremacy, having regard to Article 246 of the Constitution.
I'll ask that. But first and foremost, we'll have to demarcate the fields. Now, when we go to demarcating the fields, we look at entry 52 list 1. Now, entry 52 list 1 uses the word industry. There can be a declaration by Parliament with regard to an industry. Now, the obvious question which I would like to answer is, supposing there is no declaration of Parliament and entry 52 is not utilized, then where does this word industry go? It goes to entry 24. So there is an inherent link between entry 24 and 52, and 52 only borrows from entry 24 and not anything else. So when I am placing it in entry 8, intoxicating liquor, then the union cannot take it over because that's the plenary jurisdiction of the state independent of entry 24.
That too, really speaking, your submissions boil down to 2 limbs. First limb, that industrial alcohol falls within the ambit of entry 8 of list 2. If it falls within the ambit of entry 8 of list 2, it's a specific entry dealing with intoxicating liquors. Therefore, it does not fall in entry 24 of list 2. Since it does not fall in entry 24 of list 2, and it is only entry 24 of list 2 which is subject to entry 51, Industrial alcohol is not subject to the overriding power of Parliament under entry 52 of list 1. That's one.
Entry 8 is not subject to.
Right. Therefore, that's one. Second, you say even assuming that industrial alcohol does not fall within the ambit of entry 8 of list 2, then in that event, and assuming, arguendo, that it falls under entry 52 of list 1, section 18G contemplates that there has to be a notified order, and in the absence of notified order, the subject is not within the fold of Parliament, it falls within entry 33 of list 3.
And for this, Lordship is aware of Tikaram Ji is the famous case, where it says that. Tikaram Ji, and then from there starting...
And a declaration by Parliament under entry 52 of list 1 notwithstanding, certain aspects are taken over, certain subjects which would otherwise fall under entry 52 have been placed in entry 33 of list 3.
Right.
And therefore, the state power to regulate under entry 33 of list 3 will include the power to levy a fee.
Otherwise, the consequence would be, my lord, that all these entries 8, 25, they all will be rendered nugatory and empty by drawing power from IDR Act. Now, here we'll be conferring Parliament the jurisdiction to take away not the power, plenary powers of the state legislature, which are not subject to, which are independent powers. So we can't adopt this.
Even assuming that a declaration is issued by Parliament under entry 52 of list 1, notwithstanding that, it's evident from entry 33 that yet trade and commerce, production, supply, distribution comes within entry 33, because entry 33 clause A covers only those industries which are declared under entry 52 of list 1.
Right. And Lord, the other thing is, Lord, if Lordship would see the Calcutta gas case, a constitutional bench judgment, not the first case, where they considered this issue and they struck down IDR on the ground that you can't take over gas and gas works.
We'll come back after lunch. Now, Mr. Dwivedi, I think now we can wrap up in a short while because we have made very substantial progress. I think you've understood your point. Lord, sir, now you can show us whatever remains in half an hour or so.
We've made so much of an effort. Kindly give us some more time.
Oh, yes, of course. We'll run.
Pour in our effort, not perhaps.
Yes, of course. We'll look at the case law. We'll run through now your written submission and see what case law needs to be looked at. We have seen the essence of your submission.
I'm great. Lord, appreciating lots of concern for early finish, Lord, I'm sorry.
It was just one mentionable item, you know.
Yes.
The chillness of the.
It was cold, huh?
I'm sorry for that.
Appreciating lots of concern for early, Lord, and fast finish, Lord. I have revised my argument in a different way. So all that I would suggest now is just a recapitulation that industrial alcohol must be understood in the context of the legal sense, that is the legislative history. If seen, what it means is that it is part of intoxicating liquor. If it is part of intoxicating liquor in entry 8, then it cannot be there in entry 24. Because the union stand is only that it is there in entry 24 drawn to entry 52. So all that we have to answer here is that it can't be in entry 24. Intoxicating liquor in entry 8 is not subject to, unlike entry 24. Coming to this issue of paramountcy, Lord, we must take note of this fact. Paramountcy is a question which is resorted to only as an ultimate resort when the conflict is there and it cannot be resolved in any way. Otherwise, the rule of paramountcy is not applied. What is applied is the issue of within substance, which your lordships have devised, stating that the subjects will include the ancillary and as well as the incidental factors, which can be legislated upon by the relevant legislature. But this, what lordships have held is that incidental encroachment on the state list can never imply reduction in state's jurisdiction. It can at best save the law, which is in dispute, but it cannot tantamount to restricting the scope of the legislative entry, which is within the state jurisdiction or state's legislative power, which is independent. States are in the federal polity, they are equally plenary, they are equally sovereign, sharing the sovereignty. So we can't perhaps cut short states' power through parliamentary declarations. That would be most damaging for the federal structure. Because every time Parliament legislates on its own subject and incidentally encroaches upon the state list, the lordships may hold it as valid, applying the doctrine of within substance, which means in substance the act is within its own list. But if by that principle we are going to take away the power of the state in respect of one entry, which is independent, then imagine what will happen, Lord. Most of the cases, Parliament will legislate on incidental and ancillary issues, and it will continue to prevail over the state's jurisdiction. Where will be ultimately, where will it go? How far will it go? So that argument would be entirely destructive of the federal structure and should never be adopted. That's what lordships have always done, and I'll show the decisions. But there also lordships have sounded a caveat that where the dominant legislature, that is the legislature in whose list the subject is, when the dominant legislature legislates, and even if it conflicts with the incidental encroachment by the union, then the law made by the dominant legislature will prevail.
Yes.
That is what Justice Rumapal said in ITC, and that has been followed. I'll give lordships a reference of that judgment. In 2018, Volume 4 SCC, 743, paragraph 39 to 43. It's gone. AP, please speak.
Page.
I'll give the reference for page number. Lord Lordships have time and again decried this fact, that we must not adopt an attitude which whittles down the state's power. That's the word used, right from perhaps 1993, 9 judges Constitution bench. And that has been accepted right throughout up till now. That word whittling down the state's power is anti-federal has been accepted. And this would be a classic case of whittling down the state's power. Under entry 52, which is Parliament's declaration. That means Parliament by law can take away the power of the state to regulate some industry which is within its own exclusive sphere. But that decision is Volume 5C, PDF page 1.
The laptop is being displayed here.
Let's see that. Jayant Verma.
Yeah. Paragraph 39 to 43. Paragraph 39, which is PDF page 38.
PDF page.
भाई ये है यहाँ से 38 है यहाँ. अच्छा, PDF page 39, not in judgment. My immaturity in this field, perhaps, exposes itself.
Doesn't matter. In few more hearings like this, and you'll be absolutely on track. But we must appreciate that you're making the effort. That's really to be appreciated, honestly.
I'm grateful, Lord, but my problem is, which it's a kind of a lurking suspicion, what happens post-November? Would we continue like this or not? That's the issue.
Once it becomes a part of your life, it becomes a part of your life.
Let's hope.
Imagine, when we did 370 with a number of volumes and the 5 judges, it would have taken thrice as much of time to resolve the Article 370 case if we didn't have our computers. 5 judges, here 9 judges, 9 court masters having to hand over individual volumes, multiple volumes, every time something is cited. One really shudders about how this was done, in the earlier times.
So far as the employment situation in the country is concerned, this would be anti-employment.
No, the court masters are all gainfully employed. They're doing something else.
Anyway, coming back to this one, paragraph 39.
Yes.
Shri Bhushan then relied upon a concurring judgment of Ranganathan J. in Federation of Hotel and Restaurant Association of India versus Union of India. In para 74, the learned judge, while upholding the Hotel Receipts Tax Act 1980, held that in pith substance it was referable to entry 82, list 1, being in substance a tax on income. In particular, Shri Bhushan relied upon the statement of law that since Parliament had exclusive power under Article 246, 1 and 3 of the Constitution to make law with respect to any of the matters enumerated in List 1, if an Act of Parliament is clearly covered by an entry in Union List, no restriction can be read into the power of Parliament to make law in regard thereto. This was made in the context of taxation entry, which are, as the aforesaid para 74 itself states, refer to the constitutional scheme, which neatly divides the subject matter of tax between union and the states, so that there can be said to be no overlapping. There is no discussion in this paragraph of parliamentary paramountcy in the context of incidental trenching and unoccupied field. This judgment, therefore, does not take the matter very much further. Insofar as 246 is concerned, we have already seen how the said article refers to federal supremacy insofar as whittling down a state list entry is concerned when compared to union list entry. Once the sphere of both the entries have been delineated, the doctrine of pith and substance comes in to test whether a particular legislation is referable as a whole to an entry in the list or to the competing entry in list 2. Once it is found that the legislation as a whole is referable to an entry in list 1, but is incidentally encroaches upon an entry in list 2, there is no reason for the doctrine of unoccupied field not to apply in federal legislation. The expression with respect to appears in all the clauses of Article 246, which expression, so far as clauses 1 to 3 are concerned, imports the twin doctrine of incidental trenching and unoccupied field, which applies therefore to legislation made under clause 1 to 3 of Article 246, thus making it clear that incidental encroachment by Parliament cannot be tolerated when the exclusive field allotted to the state legislature is not occupied. The paramountcy principle contained in Article 246, as we have seen, is only taken as a last resort after harmonious construction fails, and that too qua entries in competing lists. Once legislation is referable to one list or the other, the doctrine of incidental trenching and occupied field would apply equally to both parliamentary and state legislatures. In the very first judgment, Federal Court, Central Province in Bharat, Sales and of Motor Spirit and Lubricants Taxation Act 1938, in re AIR at page 31, Jaker J set out a principle that were evolved on reading of British North America Act by the Privy Council, which would prove to be a useful guide to the construction of Section 100, the Government of India Act 1935. Now, Your Lordship may leave that for a moment. These are principles, Your Lordship may look into it, but last clause which have been perhaps identified for even where there has been an endeavor to give preeminence to the central legislature in cases of a conflict of powers, it is obvious that in some cases where this apparent conflict exists, the legislature could not have intended that powers exclusively assigned to the provincial legislature should be absorbed in those given to the central legislature. Kindly keep that in mind. Then, Lord, they refer to the para 42. The federal structure under the constitutional scheme can also work to nullify an incidental encroachment made by the parliamentary legislation on the subject of a state legislation where the dominant legislation is the state legislation. An attempt to keep the aforesaid constitutional balance intact and give a limited operation to the doctrine of federal supremacy can be discerned in the concurring judgment of Ruapal J in ITC Limited versus Agriculture Produce Marketing Committee. This is a constitutional benchmark, wherein after quoting the observations of this court in SR Bimai, the learned judge had gone to observe as follows. The fact that under the scheme of our constitution, greater power is conferred upon the center vis-a-vis the states does not mean that the states are mere appendages to the center. May I pause here? I recall what Lordships had observed in Delhi matter. Lord. States are not satellites and appendages of the center. They have their own unique sphere. defined by the Constitution. Within the sphere allotted to them, states are supreme. Center cannot tamper with their powers. More particularly, the court should not adopt an approach, an interpretation which has the effect of or tends to have the effect of whittling down the powers reserved to the states. The next
down to whether
But the next paragraph is equally important. No?
yeah.
Although Parliament cannot legislate on any of the entries in the state list, it may do so incidentally while essentially legislating within the entries under the union list. Conversely, the state legislature may encroach on the union list, which, when such an encroachment is merely ancillary to an exercise of power intrinsically under the state list. The fact of encroachment does not affect the wires of the law, even as regards the area of encroachment. This principle, commonly known as doctrine of fifth substance, does not amount to an extension of the legislative field. Therefore, such incidental encroachment is either event does not deprive the state. Such incidental encroachment in either event does not deprive the state legislature in the first case or Parliament in the second of their exclusive powers under the entry so encroached upon. In the event the incidental encroachment conflicts with the legislation actually enacted by the dominant power, the dominant legislation will prevail. Otherwise, the entire concept would be anti-federal.
Yes. What else, Mr.
Now, what I was submitting here is, and I'll run through it very fast. I had already placed large portions of my written submission, but so far as it is based on the legal history in the legal sense, Lordships can look into it. But I would not read the entire thing because it would be just repetition of what I
tabulated statement which was
page 16 to 16 to 22. And I have referred those principles which I have evolved with case laws. No? And this case law, which is specified point-wise, buttresses what I'm arguing. But then eventually, what I would submit with respect is the last of these, page 22, the last paragraph, therefore any declaration have Lordship got it?
Yes.
Page 22. Therefore, any declaration under entry 52 list 1 only draws jurisdiction from entry 24 list 2 and cannot affect state legislature's power under any entry other than entry 24 list 2. This is settled position by various constitution benches of this court. Entry 24 is a general entry while special entry are excluded from it. This is also settled by the above judgments, particularly the following. 62 is a very clear-cut case in this regard, because it pertains to, as I had shown, entry 25 list 2, gas and gas works. IDR took over that. He said you can't do that, and they struck down. Likewise, 80 volume 4 SCC 136. This is a case Ishwari Khaitan, where issue was acquisition of a company, read into entry 43 list 3. So they said entry 52 cannot take over the power from entry 42 list 3. Then 81 4 SCC 391. This is Southern Pharma, Lord, where again medicinal and toilet preparations were held to be within intoxicating liquor, as defined in Balsara. Medicinal toilet preparations containing alcohol, they were held to be within intoxicating liquor. Then note 96 volume 3 SCC 709 is extremely critical. People considers this argument in detail and then holds that entry 8 cannot be taken over under entry 52. Now, of course, that case was of a potable liquor. But then what applies to potable liquor will equally apply to non-potable liquor if intoxicating liquor includes industrial alcohol. So this is direct authority which will help our cause. And last of all, without wasting lots of time, I would pray kindly allow me to place this judgment, 2002, 9 SCC.
We also see 96 for a moment. I mean, I think, since you said it's very...
Would you Lordship like to see?
Just for 2 minutes, let's have a look at it.
Volume 5, PDF page 2036. And paras are 25 to 38.
Mr. Dwivedi, why are you going to your bound volume when it comes to the cases? You're going that far, on your pleadings.
There's a slight kink in the mind, Lord, that we underline it while reading. So when something comes without underlining, I feel absolutely
but you can underline. We underline all the time over here when you're reading, because when you're dictating the judgment, you look at what you underline.
I know what Lordship's saying. I'll follow that.
You'll be able to underline as well. I'm sure your junior will tell you that little trick.
No, I have not. I have all the equipment.
You have the stylus and everything. But even without the stylus, you can underline.
Yeah, that's true.
2036, volume 5, is it?
Money.
No, that is McDowell.
McDowell.
All right, 96.
This is a case, particularly in relation to potable alcohol.
Para?
Yes, 25 to 38. Para 25. PDF page is 2054. To 38. This would also greatly answer my Lord Justice Nagaratna's problem that arose time and again. This will answer that. Entries aforementioned disclose the following features. They refer to those entries, not entry 33, 52. Lordship can see in the earlier paragraph. Entry 8, paragraph 23. We may now notice the relevant entries in our Constitution. Entry 6, 8, 6, 24, 51 in list 2, the 7th schedule to the Constitution read thus. Lordships have already seen, so I have not wasted Lordship's time on that. Entry 33 in list 3 was substituted by Constitution 3rd Amendment Act 1954. The background to this entry is explained by this court in Tikaramji versus State of UP. Entry 33 of list 3 reads, trade and commerce in and production, supply and distribution of the A products of any industry where the control of such industry by the union is declared by Parliament by law to be expedient in the public interest and imported goods of the same kind as such products. Foodstuff, edible oil, including cattle fodder, raw cotton, Lordship, but that, no, we are not concerned with that. But foodstuff, Lordship may keep in mind because I'll refer to that later on. The aforementioned disclose the following features. The power to make a law with respect to industries lies with the states. Entry 24, list 2. but the said entry is made expressly subject to the provisions of entry 7 and 52 in list 1. It means that if Parliament declares by law that it is expedient in public interest to take over the control of a particular industry or industries, such industry or industries get transplanted to list 1. In other words, the industries in respect of which Parliament makes a declaration contemplated by entry 52 in list 1, the states are denuded of the power to make any law with respect to them under entry 24 list 2. Parliament has indeed made the declaration contemplated in entry 52 in list 1. In section 2 of the IDR Act, which reads, the declaration as to the expediency of control by the Union, it is hereby declared that it is expedient in the public interest that the Union should take under its control the industries specified in the first schedule. By an amendment effected in 56, first schedule was amended. The Amendment Act inter alia introduced entry 26 in the scheme. It reads fermentation industry, alcohol, and products of the fermentation industry, other products of fermentation industry. The contention of the learned counsel for the petitioners is based upon these provisions. The submission is that manufacture and production of intoxicating liquor is an industrial activity falling within item 26 of the first schedule to the IDR Act. The IDR Act provides for licensing of industries mentioned in the first schedule to the Act, besides providing extensive control and regulation of such industries and their products. The grant, the renewal, and the refusal to grant or renew the license is thus the exclusive province of the centre. The state has no say in the matter. The state legislature is incompetent to prohibit manufacture of intoxicating liquors. But this argument, in our opinion, ignores the existence and the ambit of entry 8 in list 2. Entry 8 expressly speaks of production, manufacture, possession, transport, purchase, and sale of intoxicating liquors. It means that the power to make a law with respect to the said matters rests with the state legislature. What is significant is that the entry speaks expressly of production and manufacture of intoxicating liquors as well. This would mean that the industries producing and manufacturing intoxicating liquors fall within the purview of entry 8. May I pause here? Let's just must keep this in mind, that this judgment is under the shadows of synthetics too. It said that you don't have power in respect of industrial alcohol. You can only regulate potable alcohol. So it is under the shadow of that judgment that they are referring to. Applying the well-known rule of interpretation applicable to such situations, special excludes the general. We must hold that the industries engaged in production and manufacture of intoxicating liquors do not fall within entry 24, but do fall within entry 8. This was the position at the commencement of the Constitution, and this is the position today as well. Once this is so, the making of a declaration by Parliament as contemplated by entry 52 of list 1 does not have the effect of transferring or transplanting, as it may be called, the industries engaged in production and manufacture of intoxicating liquors from the state list to union list. As a matter of fact, Parliament cannot take over the control of industries engaged in the production and manufacture of intoxicating liquors by making a declaration under entry 52 of list 1. Since the said entry governs only entry 24 list 2 but not entry 8 list 2. Faced with the above position, learned counsel for the petitioner resorted to more than one argument to get over it. Firstly, it was submitted that the entries 24 and 8 should be read harmoniously, and that such harmonious reading should mean that the industries engaged in production and manufacture of intoxicating liquors would fall within entry 24, because entry 24 deals with industries as such, while entry 8, according to such reading, would be confined to matters other than production and manufacture of intoxicating liquors. It is not possible to agree with a submission which run counter to the express language of entry 8. It requires us to delete the word production and manufacture from entry 8, which is not open to us. We cannot rewrite the entry. Another limb of this argument was that only those entries manufacturing intoxicating liquors which are not within the purview of IDR Act will fall under entry 8. Now kindly see reading the definition of industrial undertaking clause D and the defining of factory in clause C of section 3 of the IDR Act, it is submitted that the two types of industries are not covered by IDR Act vis-a-vis those where manufacturing process is carried on, one, with the aid of power but with less than 50 workers, and without the aid of power with less than 100 workers. The submission is that these industries which are not within the purview of IDR Act would remain within the purview of entry 8, while the other industries would be under the control of the union. This argument is equally unacceptable. This argument is premised on the assumption that entry 52 in list 1 overrides entry 8 in list 2, as which assumption, as we shall presently point out, is without a basis and unacceptable. Moreover, industries which are exempted from IDR are exempted because the very provision of the IDR Act and not by virtue of entry 8 in list 2. The ambit and scope of constitutional entry cannot be determined with reference to the parliamentary enactment. The definition of factory in clause C of section 3 of the IDR Act may be changed tomorrow. The meaning and scope of entry 8 in list 2 does not and cannot vary with the change in the provisions of IDR. This submission too is therefore unacceptable. It was then contended that entry 52 list 1 governs not only entry 24 in list 2, but all other entries in list 2, including entry 8, insofar as it deals with industries. We cannot accept this submission either. A perusal of list 2 would show that whenever a particular entry was intended to be made subject to an entry in list 1 or list 3, it has been so stated specifically. Not one but several entries in list 2 are made subject to one or the other entry in list 1 or list 3. See entry 2, 13, 17, 22, 23, 26, 27 and 33. Certain other entries use a different phraseology to demarcate the sphere of the union and the state. For example, entry 32, incorporation, regulation and winding up of the corporation, other than those. Likewise, note entry 51, list 2. All this shows that whenever a particular entry in list 2 is sought to be made subject to another entry in list 1 or 2, or where a demarcation is sought to be made between union and the states, within a particular head of legislation, the founding fathers have taken care to say so expressly. We cannot therefore accept the argument of the learned counsel for the petitioners in that entry 52 in list 1 impinges upon, overrides and governs entry 8 in list 2 as well. It does not. We must make it clear that entry 8 speaks of only intoxicating liquors and does not therefore apply to or take in liquors which do not fall within the expression intoxicating liquors. The power to make a law with respect to production and manufacture of intoxicating liquors is that of the state alone. The prohibition of production and manufacture of intoxicating liquors too squarely falls within four corners of entry 8, read with entry 6 of list 2. This was the decision of the Constitution bench in Code Distillery. Article 47, then they refer to, then Lordship have, they refer to
37, straight away.
37.
Yes.
Man.
That will cover Calcutta Gas Company.
Man. I'm great.
Again,
we may, in this connection, and this is the first case where this principle was evolved.
Correct.
We may, in this connection, refer to Constitution-based discussion, this decision of this court in Calcutta Gas versus State of West Bengal, which furnishes a complete answer to the petitioner's contention on this court. The West Bengal legislature passed an act, West Bengal Oriental Gas Company Act 1960, with a view to take over the management and control of the undertaking of the Oriental Gas Company. Notifications were issued under the Act taking over the company, which was questioned by way of a writ petition in Calcutta High Court. The writ petition was dismissed, whereupon the matter was brought to this court. The main contention on behalf of the appellant was that the West Bengal legislature has no legislative competence to enact the said act. It was submitted that by virtue of Industries Development Regulation Act 1951, which contains a declaration in terms of entry 52 in list 1 and the schedule thereof, included fuel gas, coal gas, natural gas, and the like, under item 2.3, the power to make law with respect to those industries engaged in the manufacture of gas has been vested in the union, and that state has been totally denuded of that power. It was contended that entry 24 in list 2 takes in all industries, and that entry 25, which reads gas and gas works, should be confined to matters other than those covered by entry 24. Inasmuch as impugned enactment was a law relating to gas industry, it was submitted the act made by the state legislature is incompetent and void. Reliance was also placed upon Article 246 of the Constitution. All these contentions were negatived after referring to the provisions of IDR Act and the impugned West Bengal Act, the relevant entries in the 7th schedule to the Constitution, including entries 7 and 52 in list 1, entries 24 to 27 in list 2. And the principle governing the interpretation of the entries in 7th schedule, the court indicated that the matter was susceptible to 3 possible constructions. Entry 24 of list 2, which provides for industries, generally covers the industrial aspect of gas and gas works, leaving entry 25 to provide for other aspects of gas and gas works. Entry 24 provides generally for industries, and entry 25 carves out of it the specific industry of gas and gas works, with the result that the industry of gas and gas works is excluded from entry 24. And 3, the industry of gas and gas works falls under both the entries, that is, there is a real overlapping of the said entries. The court opined that having regard to the well-settled principles relating to interpretation of these entries, that interpretation which reconciles and harmonizes the contending entries should be adopted and held. And entry 24 in list 2, in its widest amplitude, takes in all industries, including that of gas and gas works. So too, entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the 2 entries, and they overlap each other. In such a contingency, the doctrine of harmonious construction must be invoked. If industry in entry 24 is interpreted to include gas and gas works, entry 25 may become redundant. And in the context of succeeding entries, namely entry 26 dealing with trade and commerce, and entry 27 dealing with production, supply and distribution of goods, it will be deprived of all its content and reduced to useless lumber. On the other hand, the alternative contention enables entries 24 and 25 to operate fully in their respective fields. While entry 24 covers a wide field, that is the field of the entire industry in the state, entry 25 dealing with gas and gas works can be confined to a specific entry, that is the gas industry. It is therefore clear that the scheme of the harmonious construction suggested on behalf of the state gives full and effective scope of operation for both the entries in their respective fields, while that suggested by the Learned Counsel for the appellant deprives entry 25 of all its content and makes it redundant. The former interpretation must therefore be accepted in preference to the latter. In this view, gas and gas works are within the exclusive field allotted to the state. On this interpretation, the argument of the Attorney General that under 246 of the Constitution, the legislative power of the state is subject to that of the Parliament ceases to have any force for the gas industry is outside the field of legislative field of Parliament and is within the exclusive field of the legislature of the state. We therefore hold that the impugned act was within the legislative competence of the state Bengal legislature and was therefore validly made. The court proceeded to hold further. Lordship, over the rest, it's a repetition rest not, but then again, the ratio of the above decision fully supports what we have said here and before. In fact, entry 8 is more specific than entry 25 in list 2, while entry 25 merely speaks of gas and gas works. Entry 8 expressly speaks of production and manufacture besides possession, transport, purchase and sale of intoxicating liquors. The ratio of Calcutta gas case fully supports our conclusion that the industries engaged in production and manufacture of intoxicating liquors are outside the purview of entry 24 and fairly squarely fall within entry 8 in list 2, and that entry 52 in list 1 does not override or impinge upon entry 8 in list 2. According to this decision, the expression industry in both entry 24 and entry 52 in list 1 must carry the same meaning. which means that if a particular industry is not within the purview of entry 24 in list 2, it would not equally be within the purview of entry 52 list 1. The decision also supports our conclusion. Article 246 cannot be invoked to deprive the state legislature of the powers inhering in them by virtue of entries in list 2. To wit, once enactment in with and substance is relatable to entry 8 in list 2, or for that matter, any other entry in list 2, Article 246 cannot be brought in to yet hold that state legislature is not competent. Now, what is important here again is, what is Lord, what is important is, Lord, that all these decisions are based on what we call the word industry. Lord, one word industry in entry 24, as the judgment say, has the same meaning as in entry 52. But what is the scope of this word industry? And that is where Tikaramji is the locus classicus.
Yes.
Which is 1956. Is it 1956 SCR 393. PDF page 80. 80. And this Tikaramji's case still holds the field. And
Mr. Trivedi, you read, we discussed Calcutta Gas Company, right? That is volume 5, page PDF 2149. Just come to that judgment, para 9, where Tikaramji is elaborately discussed.
yes,
That will give a fair idea.
Lordship's right. No? Tikaramji was considered by Calcutta Gas, no? And that is for the word industry.
9, para 9 at PDF 2158.
I'm grateful.
About
2158.
15 lines
2158, right.
in the
Para 9.
descending order.
First question that occurs, if I may place, no?
Yes.
Lordship's permission. The first question that occurs to one.
Give us this thing, which page you are reading in volume?
2158.
2158. PDF page 2158.
9.
Volume 5.
2150. 2150. 2150.
Yeah. And we are at 2150.
2158.
PDF page 2158, which is
PDF 215.
that's a whole confusion. Paging. The first question, if I may place here. May I place it?
Yes.
The first question that occurs to one's mind is, what is the meaning of the expression industry in entry 24 of list 2? Is it different from the meaning of that expression in entry 52 of list 2? Whatever may be its connotation, it must bear the same meaning in both the entries, for the two entries are so interconnected that conflicting or different meanings given to them would snap the connection. Entry 24 is subject to the provisions of entry 7 and 52 list 1. Entry 7 of list 1 provides for industries declared by Parliament by law to be necessary for the purposes of defense or for the prosecution of war. And entry 52 for industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. Therefore, ordinarily industry is in the field of state legislation, but if Parliament by law makes a relevant declaration or declarations, the industry or industries so declared would be taken off its field and passed on to Parliament. In the premises, the expression industry in all the entries must be given the same meaning. Now, what is the meaning of the word industry? In Tikaramji state of UP, the expression industries is defined to mean the process of manufacture or production and does not include the raw materials used in the industry or the distribution of the products of the industry. It was contended that the word industry was a word of wide import and should be construed as including not only the process of manufacture or production, but also activities antecedent thereto, such as acquisition of raw material and subsequent thereto, such as disposal of the finished product of that industry. But that contention was not accepted. It is not necessary in this case to attempt to define the expression industry precisely or to state exhaustively all its ingredients. Assuming that the expression means only production or manufacture, would it take within its sweep production or manufacture of gas? Entry 24 in list 2 in its widest amplitude takes in all industries, including that of gas and gas works. So too, entry 25 of the said list comprehends gas industry. There is therefore an apparent conflict between the two entries and they overlap each other. In such a contingency, doctrine of harmonious construction must be invoked. Both the learned councils accept the principle while the learned Attorney General seeks to harmonize both the entries by giving the widest meaning to the word industry so as to include the industrial aspect of gas and gas works and leaving the other aspects to be covered by it. I may not list because it's covered under the McDowell, the Lordship. I've already seen that. But the critical part in Tikaramji's consideration is not entirely here. And therefore, what I want to do is not to cut short time instead of reading all those decisions. There are at least 5-7 constitution benches in that sphere. So it will be wasting time. There's one judgment of a lordships which deals with all of them, Lord, and synopsizes all those cases. Right from Tikaramji onwards till ITC, this judgment. And this is still holding the field, Lord. There's no dispute with regard to this.
Were you referring to this? I was reading the original Tikaramji. Industry in the wide sense of the term would be capable of comprising 3 different aspects. Were you reading that part?
Yes.
I'm on Tikaram.
No, that was very well dealt with in Tikaramji. All the matters, all the aspects of industry, they noted one.
You see, para 24 at volume 5, page 96, volume 5. Tikaramji begins at page 80. Yes. And if you see para 24, actually that's a crucial part of Tikaramji. See, there the question was whether the process of acquiring sugarcane, which was a raw material for the manufacture of sugar, whether that would be covered within the ambit of industry.
That they said would fall as goods under entry 26.
So just let's see that para 24 is important actually at page 96, PDF page 96.
This is
yes. The passage begins as, it is clear therefore,
yes.
I have lots of got.
Yes.
It is clear therefore that all the acts and the notifications issued thereunder by the centre in regard to sugar and sugarcane were enacted in exercise of the concurrent jurisdiction. The exercise of such concurrent jurisdiction would not deprive the provincial legislature of similar powers which they had under the provincial legislative list. And there would therefore be no question of legislative competence.
Incompetence.
I'm sorry. incompetence qua the provincial legislatures in regard to similar pieces of legislation enacted by the latter. The provincial legislatures as well as the central legislature would be competent to enact such pieces of legislation, and no question of legislative competence would arise. It also follows as a necessary corollary that even though sugar industry was a controlled industry, none of these acts enacted by the center was in exercise of its jurisdiction under entry 52 list 1.
Now actually what follows is very important. After now, industry in the wide sense.
In the wide sense. Industry in the wide sense of the term would be capable of comprising three different aspects. One, raw materials, which are an integral part of the industrial process. Two, the process of manufacture or production. And three, the distribution of the products of the industry. The raw material would be goods, which would be comprised in entry 27 of list 2. The process of manufacture or production would be comprised in entry 24 of list 2, except where the industry was a controlled industry, when it would fall under entry 52 list 1, and the products of the industry would also be comprised in entry 27 of list 2 as goods, except where they were the products of the controlled industry, when they would fall under entry 33 list 3. This being the position, it cannot be said that the legislation which was enacted by the center in regard to sugar and sugarcane would fall within entry 52 of list 1. Before sugar industry became a controlled industry, both sugar and sugarcane fell within entry 27 of list 2. But after declaration was made under entry by Parliament under 1951, in 1951 by Act 65 of 51, sugar industry became a controlled industry, and the product of that industry, vis-a-vis sugar, was comprised in entry 33 of list 3, taking it out of entry 27 of list 2. Even so, the center as well as the provincial legislatures had concurrent jurisdiction in regard to the same. In no event could the legislation in regard to sugar and sugarcane be thus included in entry 52 of list 1. The pith in substance argument also cannot be imported here for the simple reason that when both the center as well as the state legislatures were operating in the concurrent field, there was no question of any trespass on the exclusive jurisdiction vested in the center under entry 52 of list 1. The only question that survived being whether putting both the pieces of legislation enacted and the state legislature together, there was any repugnancy in issue. And here they found there was no repugnancy because there was no central law. The conflict has to be in fact, not this is the judgment which for the first time said. There has to be a conflict in fact, and therefore you've got to legislate under the IDR Act to control this. But then the interesting part of it is not this, which Lordship may bear in mind, but kindly come to entry 33. But there is one interesting factor which Lordships may take into consideration here, again, which
difference in Tikaramji was concerned with the control over the antecedent raw material. Over here, we are not dealing with a control over the antecedent raw material. This is the heart of the industry.
But the word industry was considered and the scope of word industry was found. No, but important part is why. Question was Tikaramji is a case where on the one hand there was...
Actually, but for entry 8 of list 2, industrial alcohol would fall within the ambit of industry in entry 52 of list 1.
How would it fall? But this is a question
but for entry 8. It's an industry.
I'll answer that. No? Then we would at the same time be saying that intoxicating liquor would be only potable liquor, and industry pertaining to potable liquor would exclusively go to entry 8.
No, that's not, you have not understood the theory.
I'm saying that it is because of entry 8 that
It would not go into
entry, that doesn't go into entry 24 and doesn't go into entry 52. But if entry 8 was not there,
then it could have been.
it would have been an industry
Yes,
then within entry
yes,
52 of list 1.
Yes, no doubt about it. No doubt about it. Important thing is not entry, the Tikaramji.
Challenging the idea. So what is the ambit of the expression
I'll answer that. No?
fermentation?
In
And
Lordship has kindly again go back.
you have what is the schedule?
No, there are two answers to what Lordship's query is. No? I'm sorry.
What would be the difference between intoxicating liquor and alcohol?
Not every intoxicating liquor, as per the local acts Lordship has seen, meant all liquids containing alcohol. So every alcohol will have to be there.
Because under the entry 26 of the schedule,
But it's a changed entry.
one is
It's a modified entry.
alcohol.
This has been modified in 2016, where because of Bihar distillery, they carved out an exception against potable alcohol, which was not there earlier. When these cases were considered, McDowell, Tikaram, the position was entirely different. Only fermentation industry was specified with alcohol, word alcohol.
What was the entry before the 16?
That is substituted in
2016.
The only thing within the brackets were omitted.
That's
It
right.
was fermentation
Fermentation
industries and then one into the products, alcohol and other products of fermentation.
fermentation.
Yes.
So other than potable alcohol was added by the
2016, that are in
2016.
It was earlier fermentation industries.
And then
That bracket portion was added.
Products of fermentation industries would take an intoxicating liquor.
Normally, fermentation industry, that was the interpretation given to it. But the whole question is, can you take it? That's the question, can the parliament take it? Now, to answer the Chief Justice's query, no one has challenged. There's no doubt about it. No one has challenged the inclusion of fermentation industry. There's no doubt about it. But in Calcutta gas, no one had challenged it. Yet the court struck down that on the ground that we are deciding and deciphering the scope of legislative entry. So if the act of one of the two legislatures do not fall within that entry, then they have to go. The dominant legislature has to prevail. Likewise, in ITC, again the same thing was done. This objection was raised that no one has challenged the IDR Act. But the whole question would be that if the parliament legislates expenditure
Because if we accept your submission, I mean, not that we are saying that it's wrong, just trying to explore it. That would mean that where any industry is specified in list 2, that would include gas works, that would include intoxicating liquor, that will fall outside entry 52 of list 1.
52 of list. Entry 54 is mines and minerals. Lordship has done the mines and minerals matter, but entry 54 occurs in Lordship.
52. 52.
It would be outside that.
No, but then why does Parliament cover
That's the
prior to 2016, Parliament covers the entirety of alcohol?
Yes. But the whole issue is whether that is correct or not, because Lordships are defining the scope of the entry and Parliament is legislating on an entry which is not there in their field. So how can legislation without power is a void legislation, stillborn?
But you're appearing for whom?
State of UP. But we are the petitioners actually sitting on the wrong side, actually. That's the problem.
But are you saying, therefore, that the legislation which is enacted by Parliament is
otherwise we can't get the jurisdiction, no? Can you look at it this way? States' jurisdiction have been denied by synthetics on these great grounds, entry 52. Now, if we do not challenge that, synthetics cannot be overcome. If synthetics cannot be overcome, then what are we, due respects, reconsidering? We are considering whether synthetics, when it relies upon entry 52 to shut down states' jurisdiction in respect of intoxicating liquor, which includes industrial alcohol, that is incorrect and states' jurisdiction cannot be taken away. Synthetics took away because of entry 52 and IDR. Lord, I'll satisfy Lordships on this issue that I need not challenge. If the question arises during consideration, what is the scope of the legislative entry? And if there is any conflict, the Lordship will have to resolve the conflict. And if the Lordships resolve the conflict in the manner I am advocating, perhaps not, then the question would be clear that Centre had legislated absolutely illegally. Otherwise, Lordship would seem, even though state has jurisdiction under entry 8, yet because of parliamentary declaration or legislation, we are denied the power to legislate on our own field. Lord, whatever is troubling Lordship that no one has challenged IDR, was answered by ITC.
Legislated.
Exactly.
On an industry which falls within the scope of entry 8 of list 2.
Exactly.
Because alcohol.
Well, that is assuming it falls. The industrial alcohol, if it is part of intoxicating, then what Lordship is saying is correct. But if it has, then what will be the consequence? And the aspect that is troubling a Lordship said that since no one has challenged IDR and it has been prevailing, then what can be done? That is answered by ITC. We need not challenge it. When Lordships determine the scope of the entries, then the power of the state with respect to its own entry cannot be declined because Parliament has declared something. Otherwise, tomorrow Parliament will take over gas and gas works. Then what happens?
See, because Article 246(1), it begins with a non-obstante clause, notwithstanding anything contained in clauses 2 and 3. Clauses 2 is with regard to state list. Clauses 3 is with regard to concurrent list. Clause 3 is with regard to state list. Notwithstanding anything contained in the concurrent list and the state list, Parliament has exclusive power to do it with regard to union list.
Fine. Now, let me explain it not this way. Lordship saw in that case of Jayant Verma, the word notwithstanding is a concept which only emerges when there is an irreconcilable conflict. First, the effort should be to reconcile the conflict if it appears. The Parliament may have legislated on A entry or B entry. But the fact is, what we have to see is whether that legislation is within its field or not. And likewise, state legislation within its field or not. Now, when we find that there are two entries which are overlapping, for instance, industry, gas and gas works, they were overlapping. The court found in McDowell as well as Calcutta Gas. Now, if they were overlapping, then lordships have to evolve some principles of harmonious construction. Notwithstanding
the other harmonious way would be to say that yes, the state does have the power over intoxicating liquor.
Quite right.
But once there is a declaration made by Parliament under entry 52,
that power is taken.
Then your power is denatured.
Then which means entry 8 list 2, even though it has not been made specifically subject to entry 52, it becomes subject to like entry 24. So what are we saying is that we are reading word subject to in entry 8, which perhaps it is not open to read.
Then what is the meaning to be given to the expression notwithstanding anything contained in Article 246(1)?
I'll answer that. Notwithstanding means in case the conflict is irreconcilable harmoniously, then in that even parliamentary entry would prevail over the state entry. But the fact is, when your lordships can reconcile harmoniously, as lordships have done in the case of McDowell and Calcutta Gas, then perhaps notwithstanding clause would not operate.
That is the question.
No, but in every case,
whether we can narrow the scope of the expression industry in entry 52 list 1.
Not entry 24 list 1.
Entry 52 list 1.
For that, the answer was there in this McDowell's case. Entry 52 draws from entry 24. Now, what we have to see, what is the position in the state list with regard to word industry in the state list. Now, in the state list, industry means what? That has been determined in Calcutta Gas as well as McDowell. It means only manufacture. It would not include entry 26, 27, or any other entry that is not subject to it. For instance, Calcutta Gas, entry 25, that is also an industry, like entry 8. Now, Calcutta Gas Union took over the jurisdiction by specifying it as an idea, under the idea in the schedule. Now, despite the fact they had specified in the idea the gas and gas works, yet the court said, when we look into the entries that are there, what appears to be is that the word industry in state list would exclude those entries which are independent of and are not subject to entry 52. For instance, gas and gas works is not subject to. But if the parliament can still take it over, then what is the point in specifying 25 list 2 separately? It could have been there in the word industry.
Right. Yeah.
So long it is not taken over by the parliamentary law, it will remain with the state list. But once it comes under the IDR Act, what happens?
I think there's one thing which has been missed, Lord. I would submit with due respect. Lord, so long it is not taken over, but what can be taken over is only what is there in industry. That is entry 24. It cannot take over something which is not there in entry 24. Now, our submission is, with the support of McDowell and the other cases, that entry 24 will not include entry 8. That is what McDowell says. And it will not include entry 25. That is what Calcutta Gas says. If word industry does not include that, then you can't take it over. Parliament cannot take it over. Power of Parliament is not entirely, absolutely wide and expansive. Parliament's power cannot run amok over the state list, except so far as word industry in entry 24 is concerned. So it is 24 only which is subject to deprivation on the declaration. No other entry.
The other side on that.
Read something.
What else now remains?
Lord, I really wanted to read this judgment, Lord, which is this ITC, Lord, 2002, volume 9, SCC 232. 2002, 9 SCC 232. This is volume 5,
PDF page 1597.
PDF page 1597. This would clarify all the queries that have fallen from your lordships, and therefore I wanted to.
Volume 5.
If I may indicate the paragraphs, no? Para 10. I'll give the paragraphs which are relevant one for my purpose. Para 10, 26 to 31 or 26 to 32, 40 to 86. And this deals with the entire history with regard to the word industry, entry 52, as well as entry 24.
This is volume 5, 1597.
Yes. So instead of reading all these decisions, this has the judgments, all the judgments, Constitution bench judgments in the synopsized form. To give the gist of the dispute note, kindly come to PDF page 1617. Now, in this case, the minority judgment holds in favor of the union that the incidental encroachment would take away the power of the state. In the proposed judgment, this is the minority judgment, and Justice Sabarwal's judgment is the majority judgment. In the proposed judgment, Justice Patnaik has held that the word industry in entry 52.
Just tell us the para once again.
Para 10, PDF page 1617.
We are now referring to Justice Sabarwal's judgment, right?
Justice Sabarwal's judgment. Chief Justice Sabarwal, in fact.
Yes.
His Lordship, as his Lordship then was. No, I'm sorry, he was not the Chief Justice at that time. Justice Marucha was the Chief Justice. In the proposed judgment, Justice Patnaik has held that the word industry in entry 52 of union, and by the way, Lord, this will answer the other question too, completely. This will answer the other question too. Therefore, I chose this decision note that will save time. In the proposed judgment, Justice Patnaik has held the word industry in entry 52 of the union list cannot be given restricted meaning so as to exclude from its purview the subject of legislation coming within entry 27 or entry 14 of list 2. And thus, the parliamentary legislation, namely the Tobacco Board Act 1975, is constitutionally valid, and consequently the state legislation entitling the market committee to levy fee for sale and purchase of raw tobacco within the market area will not be operative so far as the produce of tobacco is concerned, and that the majority judgment in ITC case is correctly decided. Lordship, with the rest, kindly come to paragraph. Paragraph 26. It is PDF page 1621. Before considering the four noted decisions, it would be appropriate to make it clear that in these matters, it has to be kept in view that this court is not examining a case where the field of legislation is in the concurrent list, to which Article 246(2) applies. This court is also not considering the case of an incidental trenching of field by one or the other legislature. The court is concerned with the question of legislative competence. We are examining a case where what has been questioned is the legality of the legislation in respect of a field in the state list, to which Article 246(3) applies. The validity and applicability of the state legislation in respect of field of legislation in the state list has come under cloud on account of legislation passed by Parliament in respect of field of legislation under entry 52 of Union List, namely Tobacco Board Act 1975, It is on account of this legislation containing declaration as contemplated by entry 52 of the Union List that doubts have arisen about the validity of the applicability of state legislation about the sale of agricultural produce of tobacco in market areas and levy thereupon a market fee, which aspects are in the field of legislation in the state field, entries 14, 27, 28, 66. Entry 24 of the list 1 is subject to entry 7 and 52 of list 1. We are not concerned in these matters with entry 7. The question here is to the effect of transfer of field of legislation under entry 24 of state list to the union list, entry 52, on other fields in the state list, namely field of legislation under entries 14, 27, 28, and 66, and what in fact can be transferred. That's the question we are concerned with in this case. Now they refer to Bajnath KDM, not Lordship omit that. 28 also Lordship omit that. No? Kindly come to 31. Relying upon Ishwari Khetan's case, Mr. Shanti Bhushan contends that entry 52 has been equated with entry 54 of the union list. Both sides have relied upon Ishwari Khetan. Let us examine that case. In the Ishwari Khetan's case, the contention urged was that Parliament has made the Industrial Development and Regulation Act 51, for short IDR Act, in entry 52 of list 1 declaring control of sugar industry, and that industry goes out of entry 24 of list 2, and therefore the state legislature is denuded of the legislative powers in respect of sugar industry, and the impugned legislation was with respect to acquisition of sugar undertaking in sugar industry. The Attorney General has contended that the power to acquire property was derived from entry 42 of list 3. Ishwari Khetan's case involved a determination or scope of entry 52 of list 1 and entry 24 of list 2 only. The scope of these entries with respect to entries 26 and 27 of list 2 and entry 33 of list 3 did not fall for consideration. Paragraph 7, 8 and 11 of Ishwari Khetan, the Constitution Bench repeatedly pointed out that declaration in entry 52 of list 1 denudes the state legislature of the power to legislate under entry 24 list 2 only. Can you notice this one? Only. It was notified that sugar was declared industry. It was noticed, I'm sorry. The question posed was that it is however correct to say, that once a declaration is made as envisaged in entry 52 of list 1, that industry as a whole is taken out of entry 24 list 2. The answer given by the Constitution Bench was that it is not correct to say that once a declaration is made in respect of industry, that industry as a whole is taken out of entry 24 list 2. It was said that the industry as a legislative head finds place in entry 24 of list 2. The state legislature can be denied legislative power under entry 24 to the extent Parliament makes a declaration under 52, and by such declaration Parliament acquired power to legislate only in respect of those industries in respect of which declaration is made, and to that extent as manifested by the legislation incorporating the declaration and not more. Lordship would recall that initially Lordships had posed this question that entry 52 does not use the word to the extent. The bench further said that the legislative power of the state under entry 24 list 2 is eroded only to the extent the control is assumed by the union pursuant to the declaration, and the state legislature which is otherwise competent to deal with industry under entry 24 list 2 can deal with that industry in exercise of other powers enabling it to legislate under different heads set out in list 2 and list 3, and this power cannot be denied to the state. The extent of parliamentary legislation can only was seen only to determine how much is taken out from entry 24 list 2, and not for the purposes of laying down any principle that parliamentary legislation has to be seen to determine the extent of control and delineation of the power of the state legislature. To the extent the control is laid down by Parliament. Further, it was held that despite the parliamentary legislation, the state legislature can deal with industry in exercise of other powers in different entries in list 2 and list 3, and that power cannot be denied to the state. In this case, the court was examining whether the law of acquisition of sugar undertaking was referable to entry 24 list 2 or entry 24 list 3, 42 list 3, it was contended that the acquisition of property was referable to entry 42 list 3. The scope of examination in Ishwari Ketan's case, there is no discussion on the interpretation of the expression industry, and that probably is the reason why Tikaramji's case has not been referred to. The reliance of Vaishnath KDO in Ishwari Ketan's case was to show the denudation of the state's power being limited to the extent of control. While Vaishnath KDO dealt with entry 23 list 2, Ishwari Ketan case dealt with entry 24 list 2. The subject matter of other entries was not an issue in the decision. The structure of entry 54 of list 1 was not equated with that of entry 52 list 1 as contended by Shri Shantibhushan. This decision does not adopt the mines and mineral cases for the purposes of considering the scope of entry 52 list 1. In our view, the case of mines and minerals are not of much assistance while examining the scope of entry 52 list 1. In State of AP versus McDowell, also, it was held that the ambit and scope of the constitutional entry cannot be determined with a reference to parliamentary enactment. It is otherwise it would result in Parliament enacting and or amending an enactment, thereby controlling the ambit and scope of the constitutional provision. If it is otherwise, I'm sorry, but I missed this phrase, if it is otherwise. That cannot be the law. The power to legislate with which we are concerned is contained in Article 246. The field are demarcated in various entries. On reading both, it has to be decided whether the legislature concerned is competent to legislate when its validity is questioned. The ambit and scope of entry cannot be determined with reference to any parliamentary enactment. Tikaramji's case is required to be examined in detail, since that has been the bone of serious elaborate submissions in that case. They challenged by the sugarcane growers hailing from several villages of the state of UP was to the validity of UP Sugarcane Regulation of Supply and Purchase Act 53 and notification issued thereunder. A short history of legislation enacted by the centre as well as province of UP in regard to sugar and sugarcane was noticed. Then Lordship omit that. Kindly come to perhaps para 40. PDF page 1626. On 31-10-51, Parliament enacted the Industries Development Regulation Act 51 to provide for the development and regulation of certain industries. By Section 2 of the Act, it was declared that it was expedient in the public interest that the union should take in its control the industries specified in first schedule. The schedule included industry engaged in the manufacture or production of sugar. The UP legislature enacted Impugned Act. The object of it was as follows. With the promulgation of Industries Development Regulation Act with effect from so-and-so, the regulation of sugar industry has been exclusively a central subject. The state government are now only concerned with the supply of sugarcane to the sugar factories. The bill is being introduced in order to provide for rational distribution of sugarcane to factories for its development on organized scientific lines, to protect the interest of the cane growers of the industry, and to put the new act permanently on the statute. In exercise of the rule-making power conferred by the Impugned Act, the UP government made rules and also promulgated UP Sugarcane Regulation Supply Purchase Order. All these related to the supplies and purchase of sugarcane in UP. Challenging the wires of the State Act, one of the submissions made in Tikaramji's case before the Constitution.
You've seen Tikaramji, why are you reading this? Actually, if you go to para 61, that's where Justice Sabharwal has summed up what he wants to see. Just see para 61 at 1632.
I'll just sing it. Can you give me 1 minute, please?
That will be your internal page 267 of the judgment.
For that.
Sabharwal says this let's see Placitum C at page 1632. Placitum C, if you have the same copy. Placidum, Shraddhan just give it to Mr. 1632, Placidum C. The expression industries
In entry 24.
in entry 24 of list 2 or entry 52 of list 1 cannot be interpreted in a manner that would make other entries of list 2 of the 7th schedule subject to union control, which in fact they are not. Wherever it was intended to be made subject to such control, whether of list 1 or that of list 3, it was said so. A perusal of list 2 shows that whenever a particular entry was intended to be made subject to an entry in list 1 or 3, it has been so stated specifically. Therefore, an interpretation which tends to have the effect of making a particular entry subject to any other entry, though not so stated in the entry, deserves to be avoided, unless that be the only possible interpretation. We do not think that such an interpretation on the entries in question, namely 52 of the union list and 24 of the state list, deserves to be placed. That is really the heart of what the learned judge said.
Right. But this one of the passages, the lordships have dealt with this issue also.
But this is a dissent, is it?
No, this is not a dissent.
Oh, this is not a dissent.
This is the majority judgment.
Yes.
Now, they have dealt with this issue, that Central Act is not challenged. IDR.
They've dealt with that. He has dealt with that as well. The learned judge says that if and when it is challenged.
No, it's come expressly. I'll show.
Para 64 at page 1633. Shraddhan, just give it to him.
If you certain other acts.
Para 64 at 1633. The validity of certain other acts, such as Cardamom Act, Central Silk Board Act, Coffee Act, so on and so forth, reference whereof was made by Mr. Shanti Bhushan, need not be examined for the purpose of considering the legislative competence.
I'll paste comment. The legislative competence of Parliament to legislate these statutes is not in issue before this court, and therefore we do not think it necessary to examine the question of legislative competence only on the academic viewpoint insofar as these legislations are. However, prima facie, there is no substance in the apprehension expressed by Mr. Shanti Bhushan that narrow approach of industry, no, not this one, but that is.
Just see the following sentence. As and when these acts are challenged.
No, I'll answer that one. Because in this case, this question was raised because no one has challenged the Central Act. Therefore, I'll just, kindly give me just a minute.
Just two sentences after that, what the Chief Justice was trying to say.
No. I'll not cut it out and give it to you lots. But they include Dixon. Carefully examine it carefully. Then it's not like that.
Actually, Tikaramji dealt with a process anterior to manufacture, namely acquisition of the raw material, which was sugarcane. They said that the acquisition of the raw material would not be comprehended within the expression of the word industry under entry 52.
Not the end, even the end product.
Right. In our case, entry 8 covers not just intoxicating liquors, but it covers
production and manufacture.
Possession, transport, purchase, and sale of intoxicating liquor. So really speaking, entry 8 would cover the entire gamut of entry 52 as well.
That's what McDowell says.
That's why a specific entry having been made by the founders of the framers of the Constitution, the entry 8 must govern.
Para 78. Can you have not para 45? Can you have para 45? Para 45, Lordship would find And in this case, they struck down the IDR specification. Even though, kindly have para 45. Two, the challenge was to the wires of the state legislation. That is page.
Not parliamentary.
Yes.
And not to the parliamentary legislation. But at the same time, the entire basis of challenge was that in respect of sugarcane, only Parliament had the power to legislate on account of field being covered under entry 52 list 1. The sugar industry having been included in the entry and the connotation of industry being very wide to include in it raw materials and sugarcane as well. Thus, the exclusive power of Parliament to legislate was urged as the main ground to seek invalidation of the state legislation. The field of sugarcane is not available to the state legislature to legislate. That's what was argued. And 46, in view of the controversy as aforesaid, the fact that the validity of the parliamentary legislation was not an issue in parliamentary case, in the Tikaramji case, does not in any manner affect the ratio of that decision. The point for determination in that case was substantially the same as in the present case, namely the scope of expression industries in entry 52, list 1 and entry 24, list 2. There also the point was to adopt a narrow or a wide interpretation of the expression industry. Further, the fact that it was a case of manufacturing industry under IDR Act also does not affect the ratio of the case. The interpretation placed in Tikaramji cannot be confined to industry falling under IDR Act alone. There is neither any express or implied indication in that decision to limit the scope. Then kindly have 50, which is important. At page 263, 28. Parliament. 50. The petitioners in Tikaramji's case in support of the wide construction to be placed upon the expression industry also relied upon various decisions interpreting the said term in relation to Industrial Disputes Act. What we are concerned here is not the wide construction to be put on the term industry as such, but whether the raw material of an industry which forms an integral part of the process are within the topic of industry which form the subject matter of item 52, list 1. As ancillary or subsidiary matters which can fairly or reasonably be said to be comprehended in that topic, and whether the central legislature, while legislating upon sugar industry, could acting within the sphere of entry 52 of list 1, as well legislate upon sugarcane. This court said that the legislation with regard to sugarcane came within the exclusive province of central legislature under entry 52 of list 1. The enactment passed by the provincial legislature would be ultra vires, it was said. Lordship, let us kindly come to the next one. Lordships have already seen the gist of all these cases. Now, kindly come to para 57. Para 57. 1630. Mr. Shanti Bhushan, however, contends that once the field is covered by entry 52 by issue of requisite declaration and Parliament has actually covered the field by enacting a legislation, with regard to that extent, the industry, including all facets of such an industry, whether it is raw material or the products of that industry, the state legislature will have no power to legislate. The contention is that the expression industries in entry 52 list 1 comprises in it all its aspects commencing from procurement of raw material and up to the disposal of final product of that industry, not only the process of manufacture or production. The submission of Learned Counsel is that the expression industries in the entries under consideration is not given such interpretation. It would denude the Parliament of the real object of control and such industry, in particular, in public interest, which is of paramount importance. As against this, the contention of the other side is that the acceptance of a viewpoint propounded by Sri Shanti Bhushan would mean denuding the state legislature of the power to legislate in respect manner.
of Mr. Bhushan were negative.
Negative.
Now come straight to para 78.
Very good.
Why do they say so? Come to 78.
Madam. Hence was also placed.
Acceptance of the argument of Mr. Shanti Bhushan.
Exactly. Quite right. The acceptance of the
argument.
I'm just acceptance of the argument of Mr. Shanti Bhushan would make various entries in the state list ocious and meaningless, and subject to entry 52 of list 1, despite the fact that the entries are not so worded.
Now come to para 82, where they also relied on entry 54 of the union list and entry 23 of the state list. And what is the ultimate finding?
Quite right. The structure and scope of entry 54 of the union list and entry 23 of the state list and their interrelationship is substantially different from the scope and structure of entry 24, the list of the state list, and entry 52 of the union list. The entry relating to development of mines and minerals has in it both the industry of mines and the product of minerals. And therefore, on a declaration, both mines and minerals get embedded in 54 of the union list. Therefore, it has been consistently held by this court that the declaration under entry 54, Parliament evinces an intention to occupy the field. Then kindly have the next one too. The Constitution, Balsara Sugar, this is again a Constitution benchmark. The Constitution bench examined the question regarding the legality of levy of market fee under Bihar Agriculture Produce Market Act 1960 pertaining to various commodities including sugarcane, sugar, molasses, wheat and tea. The court first dealt with the transaction of purchase of sugarcane, sugar factories, functioning of the market areas falling within the jurisdiction of respective market committees constituted under the market. It noticed that the market acts have been enacted by the Bihar legislature as per the legislative power mentioned in it by entries 26, 27 and 28 of list 2 of the 7th schedule of the Constitution. The court, however, noticed that the markets dealt with the supply and distribution of goods as well as trade and commerce therein, as it seeks to regulate the sale and purchase of agricultural produce to be carried on in the specified markets under the Act. To that extent, the court said the expression entry 33 of list 3 override the legislative power of the state legislature in connection with the legislations dealing with trade and commerce in and production, supply and distribution of goods. Thus, to the extent to which Markets Act seek to regulate the transaction of sale and purchase of sugarcane and sugar, which are foodstuff and trade and commerce therein, the Constitution bench says the Markets Act have to be enacted under the topics of the markets has held that it has to be held that Markets Act being enacted under the topics of legislative power under 26, 27, 28 of list 2 would be subjects to any other limitation under entry 33 of list 3. The contention of Mr. Dwivedi, however, that as admittedly tobacco is not foodstuff and does not fall under entry 33 of list 3, like the amendment of the Constitution made in 53, Parliament for further amendment of the Constitution can if so advised, place tobacco raw material of the industry in entry 33 of list 3 and thus confer on it the competence to legislate in respect of tobacco. Need to be examined by this court, need not be examined, by this court as being unnecessary. What we may, however, note is completely met by the comprehensive machinery provided by the sugarcane enacted by the very same legislature, which now, Your Lordship, perhaps. Then the paragraph 87, they notice other decisions which have followed this logic. 88, perhaps. The principles aforesaid would equally apply to entries 14, 27, 28 and 66 of list 2. It may further be noticed that in para 170 of Balsara Sugar Company, the Constitution bench reiterated to be expressed in Tikaramji case and also Seal's case, affirming the full bench of the Allahabad High Court, Shriram Industrial Enterprises. In view of the above, we see no compelling reason, either on account of binding precedent in the form of earlier Constitution bench judgment history and background of the framing of the Constitution, or other words used in various entries of the language in any article in the Constitution of India, to take a view which will result in denuding the power of the state legislature to legislate not in respect of field of legislation under entry and 24, but field of legislation covered by other entries in the state list on making a declaration under 52 list, union list. The Constitution bench judgment in the case of Tikaramji and other decisions following it confine the field of legislation of industries to process of manufacture, production, not to raw materials, which in view of the aforesaid, I conclude as under. The state legislation and the Tobacco Board Act 75 to the extent of sale of tobacco in market area cannot coexist. So Tobacco Board Act is the central legislation, state legislation and the Tobacco Board Act cannot coexist. The state legislatures are competent to enact legislations providing for sale of agricultural produce of tobacco in market area and their levy and for levy and collection of market fee in that one. Parliament is not competent. Can you look at this? Parliament is not competent to pass legislation in respect of goods enumerated in the aforesaid conclusion 2 while legislating in the field of legislation covered by entry 52 of the union list, under which Parliament can legislate only in respect of industries, namely the process of manufacture and education. So even though here parliamentary declaration law was not in question, yet they said Parliament cannot do it. A declaration was issued. But as I said, once the lordships come to the conclusion that the scope of the entries is to be delineated, you can't delineate that in the light of the parliamentary legislation. Then again, the question would be under which entry the law falls. And if lordships come to the conclusion that encroaches on the state list, it has to. And that is where the question of lordship in Jain Verma's case, the dominant legislature will always have the power, despite the fact that there is a parliamentary legislation covering the ancillary incidental.
Justice Rumapal's judgment from para 110 onwards, a very, very, illuminating.
Lordship may also have para 94.
94.
Which had come earlier, but then I would.
For 1647.
But 94 is very clear. No?
Right.
Although Parliament cannot legislate on any of the entries in state list, it may do so incidentally while essentially legislating within the entries under union list. Conversely, the state legislature may encroach on the union list when such an encroachment is merely ancillary to an exercise of power intrinsically in the state list. The fact of encroachment does not affect the wires of the law, even as regards the area of encroachment. This principle, commonly known as doctrine of pith and substance, does not amount to extension of the field of legislation. It does not amount to extension of the field of extension of the legislative fields. Therefore, such incidental encroachment in either event does not deprive the state legislature, in the first case of Parliament, in the second, of their exclusive powers under entry so encroached upon. In the event incidental encroachment conflicts with the legislation actually enacted by the dominant power, the dominant legislation will prevail.
I'll tell you, as we are rising today, that really that is the heart of what we have to consider. That's something which is worrying me, and we're still open on this aspect.
I thought I had closed it down.
No. Just maybe 5 minutes tomorrow on this. Then the process of reflection never stops until the last word is said. Tikaramji said that the word industry means the process of manufacture or production, and that it does not include the raw materials used in the industry or the distribution of the products of the industry. Distribution of the products is entry 26 and 27. Raw materials is not covered by entry 52. That is Tikaramji. If you come down now to ITC, which we are reading, ITC dealt with the market fee, the market fares, because it was the Agricultural Produce Market Committee. Justice Rumapal and the other judgment, Justice Sabharwal, says that applying the logic of Tikaramji, the regulation of markets and fares under entry 28
are not subject to entry 52.
Are not covered by industry. Are not covered by industry.
Yeah.
Right? And therefore, entry 66, the power to levy market fees is preserved for the states. That is the ITC. The real problem which the conundrum which we face is this, that entry 52 covers production, manufacture expressly, right? Entry 8 covers production, manufacture expressly. So there's a complete overlap between entry 52 and entry 8. Now, one answer to that is this, that if you read, therefore, both of them as overlapping and entry 52 as having predominance, then entry 8 is rendered odious. But whether two entries are so completely overlapping, because both cover production and manufacture, entry 8 expressly, entry 52 by interpretation that we have placed in Tikaramji, then what will prevail?
No. Can we have entry 52 once again? For a moment, just a minute. Entry 52.
You see, Tikaramji and all the cases subsequently were able to skirt around this issue because there was no absolute overlap. Tikaramji was, before, then, this last judgment is after markets and fees. This is a case which is directly and squarely an overlap between the two. That is the problem which...
That may not be the correct view of Tikaramji. Tikaramji, in every case, not right from Tikaramji till date, what the union and the petitioners have emphasized is that entry 52 will include not only manufacturing.
Just see para 126 of Justice Rumapal's judgment, para 126, and then we'll rise and we'll also reflect upon it in the night. To sum up, learned judge says, at page 1659,
to sum up, the word industry for the purposes of entry 52 of list 1 has been firmly confined by Tikaramji to the process of manufacture production only. Subsequently, decisions including those of our other constitution benches have reaffirmed that Tikaramji's case authoritatively defined the word industry to mean the process of manufacture or production, and that it does not include raw material used in the industry or the distribution of the product in the industry. Given the constitutional framework and weight of the judicial authority, it is not possible to accept the argument canvassing a wider meaning. But this is the critical.
Just go ahead.
To accept argument canvassing a wider meaning of the word industry, whatever the word may mean in the other context, it must be understood in the constitutional aspect as meaning manufacture or production.
Now just see para 127.
Applying the negative test as evolved in Tikaramji in this case, it would follow that the word industry in entry 24 list 2 and consequently entry 52 of list 1 does not and cannot be read to include entry 28 and 66 of list 2, which has been expressly marked out as field within the state's exclusive jurisdiction. No, this is the important.
Go ahead. Just read that para, then we'll read.
As noted earlier, entry 28 deals with markets and fairs and entry 66 with the right to levy fee in respect of, in present context, markets and fairs. Entry 52 of list 1 does not override entry 28 in list 2, nor has entry 28 in list 2 been made subject to entry 52, unlike entry 24 of list 2. This court in Balsara has also accepted the argument entry 28 of list 2 operated in its own and cannot be affected by any legislation pertaining to industry. But this part...
Now just see para 128, just one sentence. If industry does not include markets and fairs, it is important to define what markets and fairs. No, then learned judge discusses it. Therefore, all these judgments really say that, look, entry 52 does not cover the activity which is being legislated upon by the state. And therefore, in one case, raw materials, the state can legislate. Markets and fairs, the states can legislate. We are now in a situation where both are exactly on all fours together.
Have a relook.
Production and manufacturing.
Let's have a relook at Calcutta Gas and McDowell.
Then what happens?
There they are dealing with industry. In Calcutta Gas, Constitution Bench was dealing with industry, gas and gas work. Entry 25 list 2.
There are two possible answers. One is to say, which is the pro-state, we say the pro-federal principle, that if the entry is not made subject to a central entry, then the state entry must have its full operation. The other is to apply, though the Constitution is federal, the Constitution is federal with a certain weight in favor of the center, and then say that whether two entries overlap, then Article 246(1) will prevail. Because they cover exactly the overlapping field. There are two opposing viewpoints. Question is which one to adopt. And what do we do?
I'll come back tomorrow morning with fresh ammunition, perhaps.
Another tentative answer, if I may offer.
Sure.
Just one second, brother.
Chief Justice has given you a lot of food for thoughts, Mr. Dwivedi.
Definitely not, but
I may provide you some drink for thoughts.
That's what.
Some drink for thoughts. We are talking about different intoxicating liquor. Some require aging, some does not require aging. Some are fair, some are dark. But perhaps it may not be comprehensible to some members of the bench. Would material exhibit help?
The best thing would be not to send a bottle to each one of the
All in lighter way.
I told Brother Jamshed as we were rising for lunch that you have become a domain expert by Mr. Dwivedi's argument.
Please,
But I'm certainly, I must admit, I'm fond of liquor, but I don't mind claiming that.
I seek my lord,
But in a lighter way.
Material objections remain.
We had a trademark case. So we bought actual bottles, we bought to show the code. We went for lunch, we came back, they were all the entire consumed.
I seek my lord's leave, my lord. I seek my lord's leave, my lord. My lord, in this matter, I am appearing for UT of Puducherry, my lord. The registry is not accepting my bakala. I may be committed to that.
Yes.
Obliged.